Court officer.
ಟೋಟಲ್ 13 ಇಂದ ಕೇಳಿಸುತ್ತಾ? VC ಅಲ್ಲಿರೋರು ಆನ್ಸರ್
ಕೇಳಿಸ್ತಾ ಇದೆ ಸರ್,
ಕೇಳ್ತದೆ.
Court officer. Sir, court officer. Sir, ಇದು ಸೀರಿಯಲ್ ನಂಬರ್ 51 ಮೊನ್ನೆ 16/6 ಪೋಸ್ಟ್ ಆಗಿತ್ತು, ಮೆಮೊ ಫೈಲ್ ಮಾಡಿದೆ, ಅಬೇಟ್ ಆಗಿದ್ದ ಸಾಹೇಬ್ರು ಡಿಕ್ಟೇಷನ್ ಕೊಟ್ರು, ಮತ್ತೆ ಫೈಲ್ ಹಿಯರಿಂಗ್ ಬಂದಿದೆ ಅವತ್ತು. ಒಂದ್ ನಾನು ಕೋರ್ಟ್ ಅಲ್ಲೇ ಮೆಮೊ ಬರ್ದ್ಕೊಡಿ ಅಂದ್ರು, ಅಬೇಟ್ ಆಗಿದೆ. 4/5/2012 ಅಲ್ಲೇ ಅಪೆಲೆಂಟ್ ತೀರ್ಕೊಂಡಿದ್ದಾರೆ. ನಾ ಮೆಮೊನು ಹಾಕಿದೆ ಅವತ್ತು, ಮೊನ್ನೆ ಇತ್ತು, ಲಾಸ್ಟ್ ವೀಕ್ 16/6. ಫಿಸಿಕಲ್ ಪ್ರೆಸೆಂಟ್ ಇದ್ದೆ.
Page number 1, serial number 1 to 3. Page number 2, serial number 4 to 7. Page number 3, serial number 8 to 10. Serial number, page number 4, serial number 11 to 15.
Appellants 1, 3, and 5, my lord. Memo has been filed for the withdrawal. Unfortunately, my name has not been shown in the record, my lord. Hello, my lord. I'm appealing for appellants 1, 3, and 5, my lord. The memo has been filed for withdrawal of this thing, and my name has not been shown with Rogers.
Matter is read to you. Yes. Page number 5, serial number 16 to 19.
Your Honor, serial number 19, Your Honor.
Yes.
We have not filed the paper book. The case is from trial court records have to come from Davangere, Your Honor. Kindly pray for 4 weeks time, Your Honor.
For appeal for whom, Mr.
I'm appealing for the appellant, Your Honor.
4 weeks time is granted to file a paper book. Weeks time is granted to pay the process.
Grateful, Your Honor.
Serial number 20 to 23. Page number 7, serial number 24 to 27. Page number 8, serial number 28 and 29.
29, my lord. I am
Yes.
appearing for the appellant. Other side inform ಮಾಡಿದ್ದೀನಿ. ಇವತ್ತು ಸೀನಿಯರ್ ಮಗಳದ ಅಡ್ಮಿಷನ್ ಇದೆ. ಮಂಡೇಗೆ ಹಾಕೊಳ್ಳಿ ಸುಮ್ಮನೆ. ನಾನು ಕಂಟೆಂಪ್ಟ್ ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿದ್ದೀನಿ. Monday.
Appear for respondents in both the cases. This is what they do, my lord. Every day they file an application. Now, day before yesterday, your lordship was pleased to post it today. And today they filed an application. Therefore, it has come in the order matter. Now they want.
What is that application you have filed today?
Contempt application. They have violated the orders of the honorable court by filed a contempt application. It has to be heard on Monday, my lord. ಇವತ್ತು ಅಡ್ಮಿಷನ್ ಇದೆ ಮಗಳು.
They came to my office to serve the copy. Said they will argue on the merit.
ಕಾಪಿ ತಗೊಳ್ಳಿಲ್ಲ ಅವರು.
Along with the merit. ಈಗ ಅದಕ್ಕೆ argue ಮಾಡಬೇಕಾದ್ರೆ court's time will be wasted.
No, it is not that court time wasting. If it is violated the court order.
ಕಾಪಿ ರಿಸೀವ್ ಮಾಡ್ಕೊಳ್ಳಿಲ್ಲ.
The order is not to alienate.
That I will see when either today or Monday.
Monday.
An application.
I'll have filed that there is a violation. If there is no violation, then I will say that argue on merit. Otherwise, that we'll see on that application itself. If there is a violation, then we have to protect the order of the court.
ಕಾಪಿ ಕೊಡಕ್ ಬರೋ ತಗೊಳ್ಳಿಲ್ಲ. ತಗೊಳ್ಳಲ್ಲ ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡ್ತೀನಿ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಅಂತಾರೆ. ಅದಕ್ಕೆ
take that copy. Whatever reply you have, you give the reply.
Monday.
Serial number 30 to 33.
Petitioner has given a memo seeking leave of this court to withdraw this.
Page number 10, serial number 34 to 37.
Serial number 35, my lord. Senior is not filling. Week time may be granted. Serial number 35.
Yes, you want week's time.
Yeah, my lord.
For the appellant. Reach this matter next week. 35, yes, Mr.
Manivanna.
35, my lord. Serial.
Next week or today? Yes. Yes, Mr.
Week, my lord. Next week, my lord.
35. The request of counsel for the appellant.
34.
35.
I will file a retirement memo along with intimation letter.
File it in that office, Mr. This is not an registered counter. You file it in that office.
Serial number 35 adjournment, my lord.
6 at the request of counsel for the appellant petition of 2 weeks. Yes.
For 11, serial number 38 to 40. Page number 12, serial number 41 and 42. Page number 30, serial number 43 to 45.
Serial number 45, my lord. For the appellant, because we need to seek some instruction from the parties and also have to file fresh wakalat, my lord. Serial number 45 for the appellant. Speak for 2 weeks time, my lord.
So that now we will show that whose name.
Siddharth Suman, my lord.
This is directed to delete the name of A. Suman. Show the name of Siddharth Suman. The request of counsel, leave this matter up 2 weeks.
Great.
Page number 14, serial number 46 to 49.
Fault.
46. Yeah, second appellant. I filed an wakalat. We'll see when the matter is raised.
I apply for order and R3, your lordships. I apply for order and R3. Next week it may be taken up. File is misplaced.
Yes, let us see, Mr. I have to see that file, whether that is, whether he has filed an wakalat or not. This is for an adjournment. You are arguing. Wait, Mr. We'll see that whether you have filed an wakalat or not.
Earlier he was filing the wakalat. His wakalat was there, your lordships.
Don't take out the file, Mr. ನಾನು ಫೈಲ್ ನೋಡ್ಬೇಕೋ ಬೇಡವಾ ಏನು ಅರ್ಜೆಂಟ್ಮೆಂಟ್ ಇದ್ರೆ ಅರ್ಜೆನ್ಸಿ ಇದ್ರೆ ಅಂತ ನೀವು ಇಲ್ಲೇ ಆರ್ಗ್ಯೂ ಮಾಡಿದ್ರೆ ನಾನು ಫೈಲ್ ಮಧ್ಯದಲ್ಲಿ ತೆಗೆದು ನೋಡಕ್ಕಾಗುತ್ತೆ ಐ ವಿಲ್ ಪಾಸ್ ಅನ್ ಆರ್ಡರ್
Serial number 48, my lord. Next week, my lord.
48. Yes, the request of counsel for the appellant. Is this matter next week?
Serial number 15.
It is now abroad, my lord. 2 weeks time.
Serial number
15.
Who?
LS Venkatesh.
My lord, serial number 15 for respondents 1 to 3, my lord.
Yes, you have any objection, Mr.
My lord, illa son. Can be argued.
Request of counsel for the appellant. Is this matter of 2 weeks?
My lord, serial number 51, my lord.
Yes.
My lord, this was listed on 16/6/2023, my lord. I filed a memo bringing it to the notice of this honorable court that the sole appellant has died on 4/5/2012, my lord. Appeal has abated. In fact, I also filed a memo.
Sir, I think there is a mistake there. I think LR has already been brought on record. I think last occasion we wait and the matter is solved.
Please,
On your submission, I think that order has been made. Then we have verified when signing that.
please. No copies has been served on me of the application. I shall wait.
If court order has passed, Mr., then yes. Wait when the matter. I think this is the matter. I can remember. Yes. Yes.
Now, Kumar.
I am for the appellant. 2 weeks.
Have you informed other side?
Another informed. They said they filed NOC. They have handed over NOC.
Nobody's name has been shown. Yes, at the request of counsel for the appellant. Please this matter next week.
For 2 weeks.
The request of counsel for the appellant. Please this matter of 2 weeks. Before.
Permission.
Inform other side, Mr. Appellant counsel. Yes, request of counsel for the respondent. Please this matter next week.
See to 39.
Yes.
Next week, my lord. But I will inform the other side.
For the appellant.
I have filed the paperwork along with in the office itself.
You verify in that office, madam. Normally, the paper book in respect of the respondent will also. Have you verified in that office? You verify. If it is not available, then
Please,
I
I will give it. Please.
Verify. Otherwise, you inform the court. Yes. indicated this matter would be heard finally. I'm ready. How this matter, each time is posting before different court? Because it's an IPR matter. How that office classified, it's an MS, yes. Then it is posted other, there is no court order, it has been classified as an IPR.
That court also, it was heard and it was posted for finally disposal. Then automatically comes to court, I don't.
It's a trademark dispute. No, that is true. Once it is classified, unless court has directed to reclassify this is the matter. The registry has no orders of the otherwise it's quite sick.
Earlier it was classified in GMCP side. Later, who has classified IPR? We don't. First it's a GMC. It came in total number.
GMCPC, no, maybe office objection. No, office has classified as the MFA in the beginning. But at that stage, it was on maintainability. So it came before the regular MFA bench. Yes. Thereafter, probably the office, noticing that it is a trademark infringement matter, has placed it before your lordship. No, they can't. And they have to take appropriate orders from the Honorable Chief Justice. They have to verify. Otherwise, if that land reforms matter, they will classify it as an KLR. If the court express something, then immediately office, if that power has given to that office, then if something. In fact, in the first place, it should have come before your lordship because it's an IPR matter. I don't think on that my friend will dispute. Yeah, that is not dispute. Now that when that other court has, after overruling that objection, then said, post this matter so and so for hearing.
Yes, then it was also fixed. Yes,
it comes for me. The office has to explain that. We'll ask the registry. We'll have it 2:30. We'll see if there is any Chief Justice order is there or not. Please. Please. Yes, who is that? You are appearing for?
Yes.
I
have instructions in the matter. I should file my memo with regard to that.
No, whether this matter will survive.
Lordship.
Who is that counsel who is appearing for that plaintiff? They are also not appearing last occasion also.
It's come up after time and I have tried ascertaining with my clients.
You verify whether it will survive or not.
I shall do. Yes. So next week I shall file this.
Yes. Can appear for plaintiff. Then a counsel for defendant praise each time to get instruction. Read this matter next week. 3 is also same. None appear for the appellant. None appear for the plaintiff. Read this matter.
Serial number 4, my lord, I appear for the appellant plaintiff, my lord. Lord, I pray for a week's time, my lord, because it's coming up after a long time. I'll just verify, my lord. I will file the list of witnesses, my lord. A week's time may be granted, my lord.
I think retirement. File it in the counter. This is not in the counter. This matter of 4 weeks.
Please, my lord. Please, my lord.
Understood advocate retire sole appellant court notice ಗೊತ್ತಿರೋದಿಲ್ಲ.
Court notice issued to that appellant. Report. Assent register has submitted a report stating that appellant is dead. LR has not come on record. Yes. Appeal is dismissed as abated. CH-12 for appellant. Go for retirement by for the response. And yes. Filed on a memo. Sent by parties seeking leave of this court to withdraw this appeal. More effect 5/20/22 is taken up. So appeal is dismissed as withdrawn. Serial number 8.
Lordship, there's an element of settlement. We've spoken to the counsel of the appellant also, if your lordship may refer the matter to mediation.
Mediation, please. Yes. Counsel for parties requested matter to be referred to the Bangalore Mediation Center. Request of the parties refer this matter to the Bangalore Mediation Center. You want any specific date? Is from which place?
Parties are from Bangalore.
Bangalore. Which date you want, madam?
After 4 weeks, your lordship.
Post this matter on 18th July. Parts are directed to be present before Bangalore Mediation Center. Office is directed to send that records to the Mediation Center for
Lord, I appeal for the appellant. Lord, in serial number 9.
Yes,
Lord, I request for some more time, Lord. I have taken certified copies of certain documents from the registry, which I did not have.
That IA will not survive. IA 2 of 2014 will not survive for consideration at this stage once rejected. 2 weeks time is granted.
Please, I will do it.
Filing of paper book. Commission. Password.
More accommodation.
Filing a paper book. 2 weeks time is granted to file a paper.
Maybe.
IA 1 of
This first
2013 will not survive for consideration at this stage. If rejected, 4 weeks time is granted to file a paper. Mohan.
Death on 3/6 of 2023.
ವಕಾಲತ್ತಿತ್ತು ಹುಟ್ಟಲಿಗೆ ತೀರೋಗಿದ್ದಾರೆ ಅಂತ ಹೆಸರು submitted at the bar. Senate counsel for the appellant. What is his name? And Puttalinga has no more. It is issue court notice to the appellant. Need the name of Ravi H.S. for appellant.
Application is ready. I will file a registration. My husband also no objection.
Non-filing of IA 2 between the additional LRs of the deceased. We will file it in the copy.
With no objection.
Counsel for appellant submits that IA filed in that registry. Yeah. Read this matter next week. I will release this matter next week at the request. Here, date put it in. It has been treated. CPC change, TPF and none in the.
ನಾನು ನೋಡ್ತೀನಿ ಒಂದು ಅರ್ಧ ಗಂಟೆ ನಾನು ಹೋಗ್ತೀನಿ ಇಲ್ಲಿ ಇದಿದೆ ನನಗೆ ಕೋರ್ಟ್ ಆಫ್ 39 ಮ್ಯಾಟರ್ ಇದೆ ಮುಗಿಸ್ಕೊಂಡು ಹೋಗ್ತೀನಿ ನಾನು ಚೆಕ್ ಮಾಡಿ ಅಂತ ಮಾಡಿ ಹೇಳ್ತೀನಿ.
Raju, return the file to the appellant. Next time if we granted, I'll file my retirement.
But we have taken acknowledgement.
No, my lord, that's why I'll have to send notice again and file.
Yes, the request of counsel for. Yes. IA 1 of 2017 will not survive for consideration at this stage. Hence rejected. 3 weeks time is granted to file a paper. In the meantime, you do whatever. Yes, what about this? 6 weeks time is granted to file a paper. Steps to be taken respect of R5 has not claimed for first time.
Appearing for the appellant in this case, Your Honor. Appellant has taken NOC from us.
Lakshman.
ಆಯ್ತ್ರಿ NOC ತಗೊಂಡ್ರೆ we have to file a memo for retirement.
So a week's time may be granted.
R5 not claimed. Return to
Notice issued to the respondent. Return the postal share not claimed. In service of notice to R5 is held sufficient.
Week time marriage.
The PF issue notice that which time is granted to do the needful.
It's come as interim.
Bangalore Development Authority.
R1 is served. R2 has come back as unclaimed. R2 is a private party.
Iವರು
Murgesh V. Charati.
R2 is one Srimati Shanti. It's come as done.
Number 1/3 unrepresented. Murgesh Charati is directed to take notice. Karnataka Council for the appellant is directed to serve one set of copies.
Shanti unclaimed return to
notice issued to that respondent number 2. Return in postal share unclaimed. Hence service of notice to R2 is held sufficient. You send a copy to that Charati.
The matter is admitted as we post in final hearing.
Yes, it will come. Have you filed a paper book?
The court made the file in the file.
Number 20, Prakash for appellant, the Deepak J.
Here for the
For retirement filed by the advocate for the appellant.
I filed Wakalat today, my lord.
You have filed on Wakalat for. Yes. What's your name?
KP Bhuvan.
Office T. Prakash, Karnataka Council for the appellant has filed a memo for retirement from the case. The memo is taken on record. T. Prakash, Karnataka Council is permitted to retire from the case. KP Bhuvan, KP Bhuvan, Karnataka Council has filed an Wakalat for appellant. Office is directed to show his name.
My lord, regarding paper book.
Memo for retirement, non-filing paper book.
Paper book office to calculate, my lord.
You file an application there.
Memo.
Memo ಅಲ್ಲಿ ಹಾಕ್ಬೇಕು ರಿಜಿಸ್ಟ್ರಿ ಆಮೇಲೆ ಅವ್ರು ಕ್ಯಾಲ್ಕುಲೇಟ್ ಮಾಡಿ ನಿಮಗೆ ಇಷ್ಟು ಅಮೌಂಟ್ ಅಂತ
ಆಯ್ತು.
Number 21, Varun Papireddy for appellant, Suresh P.
Varun Papireddy filing a paper book. Finally, 2 weeks time is granted to file a paper book.
Yes, 6 time maybe.
2 weeks. IA1 of 2016 will not survive for consideration at this stage. Rejected. 2 weeks time is granted to file a paper book. IA 1 and 16, 2 and 17. Connected matter ಏನಾಗಿದೆ?
Steps ತಗೋಬೇಕು.
Connected matter 2 weeks time is granted to do the needful.
23, my lord, I appear for the appellant. Kindly grant me 6 weeks time to file paper book, my lord.
4 weeks time is granted to file a paper book.
Please.
Madam, where is that? What is there?
My objections.
Appear for the appellant. Use this matter for 4 weeks.
Application pending. Application may not. Because application and another earlier. Then of the appellant number 1 may not minor.
Appellant is a minor.
Filing.
Now he has become major. Age.
19 years. There is a
Which appellant is that?
First appellant.
First appellant. What is his name? He is Swarup Prakash. Fill the application. Producer is
Aadhaar card and
IA1 of 2021 is filed for discharging the guardian of appellant number 1. There is the affidavit. For the reason stated in the affidavit, IA1 of 2021 is allowed. Guardian for appellant is discharged.
number 1 by 2023 mil for earlier mil.
Yes, IA1 of 23 for early hearing. So there is that affidavit. IA is allowed post this matter for hearing in second week of July. Permission admitted on here to receive. Yeah, 1 of 23 for permission.
That is the objection formally, but should make allow it with a direction that not to carry out any alteration outside the premise. Setback area or backyard ಅದನ್ನು ಕೇಳ್ತಾ ಇದ್ದಾರೆ. ಮನೆ ಒಳಗಡೆ ಏನ್ ಬೇಕು ಅಥವಾ ಮನೆ ಪೋರ್ಟಿಕೋದಲ್ಲಿ ಏನೋ ರಿಪೇರಿ ಬೇಕು ಅಂತ ಅದನ್ನ ಮಾಡ್ಕೊಂಡ್ರೆ
Well, which has not been used for 3 decades. Stagnation of water causing a lot of infection. ಅದು close ಮಾಡ್ಬೇಕು ಹೇಳ್ತಾರೆ.
3 decades ಒಂದು ವಾರದಲ್ಲಿ ಏನು ಆಗೋದಿಲ್ಲ. Kindly have it next week. I will argue the matter finally.
Not being argued.
Yes, he is making his submission. You make your submission, then I will. Yes. What is that? Where is your application? Yes, what is the suit for?
The plaintiff
Yes.
presents
Carry out essential repairs to the ground floor of the premises. Indra Nagar. Yes. You have no objection to conduct any repairs of the premises.
Objection.
No. For the premises, you have no surrounding area.
Consider ಮಾಡಬೇಕಿತ್ತು ಬೇಡ ತಾವೇ
Despite repeated requests to the appellant with respect to repair, this balcony is repairs do not done. Yes, madam. Sorry.
repairs because of the.
Will permit you to repair the
Yes.
premises, not outside. Inside and all, you get it repaired. Closed by what?
Which can be removed if there is any contention.
Fact, trial court and examiner, similar application was filed. When we have said no objection, they went and constructed a toilet in the this one. That is now subject matter of the appeal. So ಅದಕ್ಕೆ ಮತ್ತೊಂದು ಸರಿ ಆ ತರ ಎಲ್ಲ ಆಗೋದು ಬೇಡ. ಮನೆ ಒಳಗೆ ರಿಪೇರಿ ಆಗ್ಲೇಬೇಕು ಯಾಕಂದ್ರೆ ಮಳೆಗಾಲ ಬರ್ತಾ ಇದೆ. ಇವನ್ I do understand. ಮನೆ ಒಳಗೆ ಏನ್ ಬೇಕು ಅದು
Any constructions, only I may be permitted to close the well which is not being used, and it is becoming a.
Only I will directed to put the slab and close it.
ಆ ಸ್ಲಾಬ್ ನಾನು ಫಸ್ಟ್ ಫ್ಲೋರ್ ಅಲ್ಲಿ ಇದ್ದೀನಿ, ನಂಗೂ ಬೇಕು ಬಾವಿ.
ಇಲ್ಲ ನೀನು
ಅದಕ್ಕೆ ನೆಕ್ಸ್ಟ್ ವೀಕ್
then there is a dispute whether they are using the water and all. IA 1 of 2023 is filed seeking permission to carry out essential repairs to the ground floor of the premises number 143, 7th cross, 2nd stage, Indranagar and surrounding area. Learned counsel for the appellant has filed an objection and seriously objected for permitting to carry out any repairs that through scheduled property. However, the learned counsel for the parties peruse the affidavit filed along with the application. The interest of justice IA 1 of 2023 is allowed. The respondent number, which respondent number 9 is permitted to carry out only essential repairs to the ground floor of the premises number 143, 7th class, 2nd stage, Indranagar, inside. And request for surrounding areas is concerned is rejected.
Next week I will argue.
Yes, post this matter for hearing. Next week. How year is it?
Sufficiently old. I will.
Yes, you are ready. We will hear that matter also on 4th July. It's a partition suit.
Partition.
And what is that dispute?
Declaratory suit. ಏನಾಗಿದೆ ನಾನು ಸೆಟಲ್ಮೆಂಟ್ ಅಲ್ಲಿ ಗ್ರೌಂಡ್ ಫ್ಲೋರ್ ಬಿಟ್ಕೊಟ್ಟಿದ್ದೀನಿ ಫಾದರ್ ಇನ್ ದಿಸ್ ಮ್ಯಾಟರ್ ಮ್ಯಾಟರ್ ಫಾರ್ ಎ ಸೆಟಲ್ಮೆಂಟ್.
Why it can't be settled, madam?
Attempts have been made
Through that mediation. Now, can I refer to that mediation? Try that.
There is any, because the entire property, they are claiming that they want the entire property.
No, you are appearing for, he's a father. Father, you are appearing for?
I am for the stepson.
Son.
Yes, there. But
She is residing with whom, Mr. Madam?
The mother is
No, but she is alone or she is with any other children?
no, she's got other daughters,
Daughters with
3
you?
daughters. He's the only son. So
Son
because
is
such a condition and health was being affected, she's now
See,
residing
if
with
it
one
is
of the
settled,
daughters.
you can construct the palace if both are together. It's a son and mother. See how that thing is.
Step.
Yes, if it is both are interested, I can refer to that mediation. In the meantime, let it go before the mediation and come. If parties are, the mediator are experts, convince. Yes, in the interest of the parties, for this matter to that, for a mediation, parties are directed to be appear before Bangalore Mediation Center on 3rd July. Yes, office is directed to send that records to that mediation center. Yes. Yes, Mr.
Last declaration time was granted.
Why? What is that recalling?
There is a conditional order for non-compliance of office.
Yes, you have to comply first.
At least 2 weeks time.
Yes. Pending consideration of IA 1 of 2023 ಆಗಿದೆಯಾ?
ಆಗಿದೆ last time.
Counsel for the appellant based 2 weeks time to comply the topsy. This matter of 2 weeks.
I pay for the appellant. There are two appellants, both have died. The legal representatives are there. They don't want to prosecute the, pass an order of abatement.
Yes.
Permit me, I'll place a memo also.
Learned counsel for the appellant has filed a memo dated 22/6/2023. Ibru ಸತ್ತೋಗಿದ್ದಾರಾ?
Ibru, ತಂದೆ ಮಗ.
Both the appellants has died. The legal representatives of the appellants are not interested to prosecute this appeal. The memo dated 22/6/2023 is taken on record. The above appeal is dismissed as abated. All pending applications are disposed of. Matter.
Yes. My lord, in this matter, my lord, there are two suits, my lord. One was for injunction and one for declaration, my lord, filed by opposite parties. My lord. Our injunction suit was dismissed, and the declaration suit was declared, my lord.
Now, why it is posted for admission? We'll admit it.
Yes, my lord. Yes. And the short date may be given for hearing.
4 weeks time is granted to file a paper book.
Paper book
ಹಾಕಿದ್ದೀರಾ? ಏನ್ ಕನೆಕ್ಟೆಡ್ ಕೇಸ್ ಅಡ್ಮಿಟ್ ಆಗಿದೆಯಾ? ಈ ಮ್ಯಾಟರ್ ಅಡ್ಮಿಟ್ ಆಗುತ್ತೆ. RFA 446 of 2009. Hard admit. Post this matter for hearing in second week of July.
Date will be
Final hearing ಗೆ hearing.
very short point, my lord. Nothing.
Date means 24th July.
4th or 5th could be so very short point.
ಬೇರೆ ಮ್ಯಾಟರ್ ಯಾವುದು ಫಿಕ್ಸ್ ಮಾಡ್ಕೊಂಡಿದ್ದೀವಿ. Again it will not reach
7th or 8th.
19th.
Very well. My lord, and one more thing, my lord. Order date ಅಲ್ಲಿ, my lord, my name has to be shown. 10/2 ಅಲ್ಲಿ ಉಲ್ಟಾ ಮಾಡಿದ್ದಾರೆ. Order sheet ಅಲ್ಲಿ. First case ಅಲ್ಲಿ.
First case ಅಲ್ಲಿ.
446 of 9 ಅಲ್ಲಿ. Kulkarni's name should be deleted and my name should be shown. ಅದು ಉಲ್ಟಾ ಆಗಿದೆ.
ಅಲ್ಲ, you are appearing for the appellant.
I am appearing. Manjunath KV is appearing. My name has been deleted. Kulkarni ಅದು ಉಲ್ಟಾ ಮಾಡಿದ್ದಾರೆ last.
ಅಲ್ಲ ಎಲ್ಲಿ ಉಲ್ಟಾ ಮಾಡಿದ್ದಾರೆ? You are appearing for the appellant in which case? ಎರಡು ಕೇಸಲ್ಲಿ ನೀವು
ಎರಡು ಕೇಸಲ್ಲೂ
ಉಲ್ಟಾ ಎಲ್ಲಾಗಿದೆ.
ಅಲ್ಲ, ಫಸ್ಟ್ ಕೇಸಲ್ಲಿ ನನ್ನ ಹೆಸರು ಡಿಲೀಟ್ ಮಾಡಿದ್ದಾರೆ.
ಅಲ್ಲ, ಡಿಲೀಟ್ ಮಾಡಿದ್ದಾರೆ. ಸೆಕೆಂಡ್ ಕೇಸಲ್ಲಿ ಕರೆಕ್ಟ್ ಇದೆಯಲ್ಲ?
ಫಸ್ಟ್ ಕೇಸಲ್ಲಿ SS ಕುಲಕರ್ಣಿ ಇಲ್ಲ, ನನ್ನ ಹೆಸರು ತೋರಿಸಬೇಕಾಗಿತ್ತು. ಅವ್ರ ಹೆಸರು ಡಿಲೀಟ್ ಮಾಡಿ ನನ್ನ ಹೆಸರು ತೋರಿಸಬೇಕಾಗಿತ್ತು. ಅವ್ರ ಹೆಸರನ್ನ ಇಟ್ಕೊಂಡು ನನ್ನ ಹೆಸರು ಡಿಲೀಟ್.
ಅಲ್ಲ ಅದೇ
ಬೈ ಮಿಸ್ಟೇಕ್ ಆಗಿದೆ. ವೈಸ್ ಸಾಹೇಬ್ last
to continue to show the name of his solicitor at Leonard Council for the appellant delete. Well, order ಅಲ್ಲೇ ಹೆಂಗ್ ಆಗ್ಬಿಟ್ಟಿದೆ. It's not a mistake to office. It is a mistake in the order.
Order yes.
Leonard Council for appellant Manjunath KV submits that by mistake there is a direction to show the name of SR Kulkarni instead of Manjunath KV for the appellant in RFA 446 of 2009. Office is directed to delete the name of SR Kulkarni, show the name of Manjunath KV for the appellant in RFA 446 of 2009. Yes. What is this? We'll admit it, Mr. Yes, heard admit. 4 weeks time is granted to file a paper.
Paper book will a short matter.
That they have to say. Why dismiss?
They are waiting for the property because it's not an ancestral property. That's the reason given.
No, your contention that it is self-acquired property. What is, who are that plaintiffs? daughters are. So, you are the father.
Father.
Father ಮತ್ತೆ ಯಾರಿದಾರಲ್ಲ ಅದರ್
Brothers. Para 35 ಅಲ್ಲಿ
all sister has filed.
ಹೌದು. Para 32, 34 and 35 reasons have been given.
They are joint position whether the plaintiff are proved that dependent we are proved the truth but none it's so dependent limitation whether dependent to prove that has been will in favor of the grandson of no they have stated will and all.
That been negative. Para 35.
No, that how many witnesses have been examined?
Witnesses are examined. Not is
now that sequence there are three their side
witnesses from their side, our side 8 witnesses.
Paper book is necessary. Finally 4 weeks time is granted to file an paper. Yes.
Then we have preemptive order. Last time ಬರ್ಲಿಲ್ಲ ಅವರು. That issue matter.
Finally 4 weeks time is granted to file an paper book. Fails to do it, the appeal will dismiss without reference to the court.
Right.
For the appellant, yes, for injunction filed against the defendants. Earlier, I filed a suit for injunction against respondent 1 and 2. Temporary injunction also granted. Subsequently, bank and respondent 4 come and disturbing. Therefore, I made impleading to them. Status on the intercourt. Subsequently, third respondent appear as the application under Order 11D of CPC read with 34 of Secretariation. Injection is bank product barala anta application application year ಮಾಡಿ only against bank ಮಾತ್ರ dismiss ಮಾಡೋದಕ್ಕೆ entire suit dismiss ಮಾಡಿ ಇವಾಗ subsequent development ಆಗಿ bank loan ಏನೋ dependent number 1 clear ಮಾಡ್ಯಾರ ಕ್ಲಿಯರ್ ಮಾಡಿ subsequent ನಾನು ಪರ್ಚೇಸ್ ಮಾಡಕ್ಕಿಂತ ಮುಂಚೆ ಸೇಲ್ ಡೀಡ್ ಮಾಡ್ಕೊಟ್ಟಿದ್ದೆ ಅದನ್ನು ಕ್ಯಾನ್ಸಲ್ ಮಾಡ್ಕೊಟ್ಟಿದ್ದಾರೆ ಇವಾಗ ಮಹೇಶ್ ಅನ್ನೋರು ಮಾತ್ರ ಮಹೇಶ್ ಅಗೇನ್ಸ್ಟ್ ಮತ್ತೆ ಡಿಪೆಂಡ್ ನಂಬರ್ 1 ಅಗೇನ್ಸ್ಟ್ ಮಾತ್ರ ಇಂಜೆಕ್ಷನ್ ಸೂಟ್ ಸರ್ವೆ ಆಗುತ್ತೆ.
See, you have filed in a suit for injunction.
Against earlier I filed against dependent number 1 and 2.
Who is dependent number 1 and 2?
Developer.
You are in a you have purchased
from the dependent number 1.
You have purchased from dependent number 1.
Please.
Number 2 is that
agreement holder ನನಗೆ ಫಸ್ಟ್ ಮಾಡ್ಕೊಟ್ಟಿದ್ರು ಅಂತ ಬಂದು ತೊಂದರೆ ಕೊಡಕ್ ಬಂದಿದ್ದಕ್ಕೋಸ್ಕರ ಅವರಿಬ್ರು ಅಗೇನ್ಸ್ಟ್ ಇಂಜೆಕ್ಷನ್ ಸೂಟ್ ಹಾಕಿದ್ರು. ಸಬ್ಸಿಕ್ವೆಂಟ್ ನೋಡಿದ್ರೆ ಇವರು ನನಗೆ ಸೇಲ್ ಡೀಡ್ ಮಾಡಕ್ಕಿಂತ ಮುಂಚೆ ಇನ್ನೊಬ್ರಿಗೂ ಸೇಲ್ ಡೀಡ್ ಮಾಡಿ ಲೋನ್ ತಗೋಬಿಟ್ಟಿದ್ದಂತೆ ಫಾರ್ ನಾಮಿನಲ್ ನನಗೆ ಪೊಸಿಷನ್ ಕೊಟ್ಟಿದ್ರು. ಆಮೇಲೆ ಬ್ಯಾಂಕ್ ನ ಮತ್ತೆ ಸಬ್ಸಿಕ್ವೆಂಟ್ ಪರ್ಚೇಸ್ ನನ್ಕಿಂತ ಮುಂಚೆ ಪರ್ಚೇಸ್ ಮಾಡ್ಬಂದು ಇಂಪ್ಲೀಟ್ ಮಾಡಿದೆ. ಇಂಪ್ಲೀಟ್ ಮಾಡಿ ಸ್ಟೇಟಸ್ ಕೋ ಕಂಟಿನ್ಯೂ ಆಗಿದೆ. ಅವಾಗ ಬ್ಯಾಂಕ್ ಅವ್ರು ಬಂದು ಅಪ್ಲಿಕೇಶನ್ ಹಾಕ್ತಾರೆ ರಿಜೆಕ್ಷನ್ ಆಫ್ ಕ್ಲೈಂಟ್ ಅಗೇನ್ಸ್ಟ್ ಬ್ಯಾಂಕಿಗೆ. ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಏನ್ ಮಾಡ್ತು ಅಗೇನ್ಸ್ಟ್ ಬ್ಯಾಂಕ್ ಮಾತ್ರ ರಿಜೆಕ್ಟ್ ಮಾಡಿದೆ.
ಎಲ್ಲಿದೆ ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಈಗ ಬ್ಯಾಂಕ್ ಲೋನ್ ಎಲ್ಲ ಕ್ಲಿಯರ್ ಆಗಿದೆ
ಅದಕ್ಕೆ ತರ್ಸ್ಕೊಂಡಿದ್ರೆ ಅದನ್ನೇ
ಹಾಕಿ. That will be the traditional documents. Then I can allow that and send it back to the trial court. Unless you show that bank has no interest in this property, you can't maintain the.
ಕೊಟ್ಟಿದ್ದಾರೆ ಫುಲ್ ಕ್ಲಿಯರ್ ಆಗಿದೆ ನೋ ಡ್ಯೂ ಅಂತ ಹೇಳಿ ಕೊಟ್ಟಿದ್ದಾರೆ ಸರ್. ಅಗೇನ್ಸ್ಟ್ D4 ಲೋನ್ ಎಲ್ಲ ಕ್ಲಿಯರ್ ಆಗಿದೆ ಅಂತ
ಕ್ಲಿಯರ್ ಆಗಿ there is no any proceedings under the SARFAESI Act. Then you can proceed against the other respondents.
ಡಿಫೆಂಡ್ ನಂಬರ್ 1 and 2 ಮಾತ್ರ ಉಳಿಯಲ್ಲ ಸ್ವಾಮಿ. ಯಾಕಂದ್ರೆ 4 ಬಂದು ನಮಗೆ ಸೇಲ್ ಡೀಡ್ ಕ್ಯಾನ್ಸಲೇಷನ್ ಮಾಡ್ಕೊಂಡು ಕೊಟ್ಟಿದ್ದಾರೆ.
ಅದೆಲ್ಲ ಒಂದು ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿ.
Please.
Additional documents with all the facts. Then we'll see who is now contesting.
Only depend number 3 2 ಇವಾಗ ಏನಂದ್ರೆ 2 ಬಂದ್ಬಿಟ್ಟೇನೋ ಅವ್ರೇನು ಕಾಂಪ್ರಮೈಸ್ ಮಾಡಿಯಾರಂತೆ. ಅವರು ನನಗೆ ಅಗ್ರಿಮೆಂಟ್ ಕ್ಯಾನ್ಸಲೇಷನ್ ಮಾಡ್ಕೊಡ್ತೀನಿ ಅಂತ ಹೇಳಿಯಾರಂತೆ.
Now that who is that contesting respondent?
Only D1 and D2 ಮೇಲೋ.
ಇಲ್ಲಿ ಯಾರು respondent?
Respondent number 1 and 2.
Builder
and ಇದು ಮತ್ತೆ ಅವ್ರದಲ್ಲೂ ಏನೋ ಸೆಟಲ್ಮೆಂಟ್ ಆಗ್ತಾ ಇದೆ ಅನ್ಸುತ್ತೆ. ಅದಾಯ್ತು ಅಂದ್ರೆ ನಾನು ಸೂಟೇ ವಿಡ್ರಾ ಮಾಡ್ಕೋಬಹುದು. ಅದಕ್ಕೋಸ್ಕರ 4 weeks ಟೈಮ್ ಕೊಟ್ರೆ ಅಂತ ಮೀನ್ವೈಲ್ ಅಪ್ಲಿಕೇಶನ್ ಹಾಕ್ತೀನಿ.
For appellant praise finally 3 weeks time. Is this matter on 20th July?
ಆಗಸ್ಟ್ ಫಸ್ಟ್ ವೀಕ್ ಅಲ್ಲಿ ಕೊಡಿ ಸರ್. ಜುಲೈ ಅಲ್ಲಿ ಏನೋ ಸೆಟ್ಲ್ ಮಾಡ್ತೀನಿ ಅಂತ ಹೇಳಿ ಅಂತ ಡೆವಲಪರ್ ಎಲ್ಲ.
Is this matter 4 weeks?
Please.
I have filed the settlement now in office.
Yes, you file it in the office. Yes. You are appearing for appellant. Who is your opponent? What is this matter, Mr.? Want to pass over?
My colleague.
Number 41.
In 2 weeks time, talks are going on.
Yeah, my letter says I claimed only 18 lakhs per share. He says between 10 and 18.
No, negotiation
going on.
I don't want any property. Let him pay some amount.
ಅವರು 18 ಅಂತ ಹೇಳ್ತಾ ಇದ್ದಾರೆ, ನಾವು 10 ಅಂತ ಹೇಳಿದ್ದಾರೆ. Kindly grant 2 weeks time.
Four share, all share.
Several properties ಇದೆ, valuation
ಆಯ್ತು, ಯಾವತ್ತು ಬೇಕು ಹೇಳಿ.
after 2 weeks.
ಇಲ್ಲ ಬೇಡ, ನಮ್ಮ ಕ್ಲೈಂಟ್ ಗಲಾಟೆ ಮಾಡ್ತಾರೆ. 2006 ಅವರು ಬಹಳ ವಯಸ್ಸಾಗ್ಬಿಟ್ಟಿದೆ.
Have it on 10. 10.
11th.
11th.
Yes, Praveen Kumar for appellant, 23 years. Number 42, K. Praveen Kumar.
Yes, Praveen Kumar.
Number 42, for appellant, K. Venkata.
The R4 and R5, Your Honor, last date was posted for settlement. The party is not agreeing for settlement. Kindly post a short date for to be ready.
Yes, Mr. You are appearing for whom?
R2 and
R2. Yes. Where is that council for that? You are there. Yes. What is this matter, Mr.
Partition. In this which
What is their contention?
their contention is 3-4. One, they have set up oral fund. Court has said oral fund. Our contention is there is no partition in the original family. Therefore, this partition is not maintained. That is also maintained because his brother he has filed a with this means. If he is also dismissed.
Yes.
So that is next thing is he says self-acquisition. Most of the properties is the tenancy rate is granted or granted. You cannot say that this is the marriage. The burden has to be on him. He has not to do any evidence to show that he has any earnings to acquire this. That is all the.
You are appearing for whom, madam?
For the daughters, Your Honor, R4 and R5.
Yes. It
Short-
was settlement was. Yes, Mr. Password.
Short date, Your Honor.
Monday.
Feel large.
There is some matters next week. Is this at the request of council for both the parties lead this matter next week? Longest.
NOC ಆಗಿರೋದು. The previous council died. Therefore, I appear. Seems that some question of law is ignored. ದತ್ತಕ ಪುತ್ರ ಮತ್ತೆ ಇವ್ರ ಫಾಸ್ಟರ್ ಸನ್ನು, ದಿ ಅಪಲೆಂಟ್ ಇಸ್ ದಿ ಫಾಸ್ಟರ್ ಸನ್. ಅವರ ತಂದೆ ಎಲ್ಲ ಸಾಕೊಂಡಾದ್ಮೇಲೆ ದತ್ತು ತಗೊಂಡ್ಮೇಲೆ ಈವನ್ ದೋ ಇನ್ ದಿ ಆಬ್ಸೆನ್ಸ್ ಆಫ್ ಎನಿ ದಿ ರಿಚುಯಲ್ he was treated as a son. But ಇವ್ರನ್ನ ಅಡಾಪ್ಟ್ ಮಾಡ್ಕೊಂಡಾದ್ಮೇಲೆ ದಿ ರೆಸ್ಪಾಂಡೆಂಟ್ ವಾಸ್ ಬಾರ್ನ್. Ultimately, some property dispute was there. The mother had executed a will dividing the property. And there was a settlement also between the appellant and the respondent, dividing the property. The trial court has held that the said compromise petition or a settlement deed cannot be looked into. ಸ್ವಲ್ಪ ದತ್ತಕ ಪುತ್ರ ಮತ್ತೆ ಇದರಲ್ಲಿ ಇರೋದ್ರಿಂದ ಸ್ವಲ್ಪ ನಾನು ಸ್ವಲ್ಪ ಓದ್ಕೋತೀನಿ.
The request of council for the appellant is this matter of 2 weeks.
you want to tell? About 46, Jagadish Balika Young for appellate. Respondent.
I am hearing for the second appellant. What happened, my lord? I prepared and I filed this appeal. Thereafter, the appellant stood the file in order to engage some other. He has filed Wakalat Nama in respect of first appellant. My Wakalat is still in.
Jagadish Balika, appellant number 1, appellant number 2, and both sign ಮಾಡಿದ್ದಾರೆ.
Gurdu ಹಾಕಿದ್ರೆ I have no.
ಶ್ರೀನಿವಾಸ ಮತ್ತು ವನಜ.
See that both of them has filed an order. Or signed that wakalat for engaging the council of
Yes, yes. So my name is still shown in the this thing.
That I have. You want to delete that name? Your name is Sridhar.
No, my name is Ramo.
No, you have given NOC.
I have given NOC.
Now that Jagdish Balika has filed an wakalat.
Yes, yes.
Your name has been deleted.
For two appellants.
Yes, he has filed 1 and 2 both.
Because again, the file has sent to me back, but they have not sent the NOC. Therefore, I pray 2 weeks time. Meanwhile, I will get the.
So far, as on today, Jagdish Balika is on.
Yes, yes.
What is the suit for?
Suit for partition.
Partition submitted.
The suit for because non-joiner of necessary party. The suit was dismissed. So thereafter, I filed this up.
Non-joiner, ಯಾರನ್ನ party ಮಾಡಿಲ್ಲ.
Daughters and
They haven't arrayed the family members itself.
Then we'll send it back, Mr.
that is the area.
Yes.
Yes.
We'll consider your argument and we'll send it back. But then you can.
And I will listen to finally.
ಅಲ್ಲ ಇದ್ರಲ್ಲಿ ಹಾಕಿದ್ದೇವೆ.
Oh, today only I will do it.
No, see,
What you want to argue? You want to go back to the matter?
date may be fixed. Next week, any date may be fixed.
See, where is that finding?
Because Balika is not appearing,
Not appearing.
because he sent back the file to me, so he may not come.
Yes. See, what is that?
Issue is non-joiner of necessary party.
That sale deed dated. For that client is null and void. As stated, whether the sale deed in favor are legally necessary. The joint position. Where is that finding that they have not been held them as a party? Not on that front.
That was the observation made in the statement.
No, I didn't find that. You just give a copy to him. You give the file. He knows. That's where is that finding?
The ninth paragraph, page number 11. Internal page number 11.
Yes.
Ninth para. First dependent is having another son by name HR Satish and another daughter by name HR Shashikala, and those persons are not included as parties. It is significant to note that the plaintiffs have brought the suit seeking partition of the property allegedly inherited by first dependent from his forefather, and therefore the other son and daughter of first dependent are necessary parties to the suit.
Even after a CASA examination by the defendant not taken steps to impede other son of the daughter dependent parties to
Another son daughter of
and part of what is admitted by PWM that the husband of the defendant Sri Narayan has left. Those persons also necessary parties to the suit. Plaintiff has not taken steps to impede. Suit stated that by the police. Is also against of court cannot. Yes, Mr. That is the only ground. He is also agreeing that.
Next week.
Who is your senior?
Sir, I appeal for R5 to answer. Session was
6.
next week.
So you are appearing for
R5 to answer.
Srinivas.
Please.
Please respond. Yes, when do you want? We'll fix the date. In the meantime, you file in a wakalat also.
Yes, I will get the wakalat and I'll file next week or 2 weeks, my lord. I have to send the call the party and get the signature of Paliga.
No, we'll have it on 4th.
4th better, 10th.
And 10th. Yes. At the request of the parties, leave this matter on 10th. Number 47. appear for the appellant. Even when the matter is called on 14/6/2023, none appear for the appellant. Leave this matter tomorrow. Top of the list for orders.
49, Arun Gate for appellant, Dia Rajshekar.
Yes.
The respondent number 1 has died. We need to get the LR on record. Kindly grant some time.
File a memo.
My lord, actually, I don't have the memo.
For ಕೊಡ್ತಾರೆ file ಮಾಡಿ. Who is that? First respondent.
Yes.
Then counsel for appellant.
Appeal.
Appellant has filed a memo stating that respondent number 1 is dead. Memo is taken on record. 2 weeks time is granted to take necessary steps.
Number 51,
Statement type. Yes. G.G. Shastri.
Number 51.
Yes, possible. Number 54, B.M. Madhav Reddy, appointed advocate. No, has he produced any document to show that his date of birth has been entered wrongly? To prove that any ಪ್ರತಿವಾದಿ ಕುರಿತು ತಿಳುವಳಿಕೆ ಪತ್ರ ಮಕ್ಕಳು ಇದ್ರ ಬಗ್ಗೆ with the trial court has rejected. Right. Yes, yes. Not produced any documents. There is no. Is that- Now also to now also he is past 50 years. Not interested. Who is serial number? N. Madhava. Here for the appellant. Read this matter tomorrow at the top of the list for orders.
Pasha. Number 55. SRM Azam. Yes, Krishna for appellant. Rajan Prabhakaran. Number 56. Ramesh Babu.
Password.
For 57. Serial number 10. Same thing.
Time is granted to file a paper.
Number 38. A. Ramesh. A. Kamruddin. Serial number 38.
Yes, Mr.
The applicants have to amend the appeal, Your Lordship.
Amendment of cost type is.
Yes, Your Lordship.
Wait, ಮಂದಿ ಹುಡುಗಿ ಇತ್ತಲ್ಲ ಅವ್ರು ಇತ್ತ Yes, leave this matter next week. Or let them. Yes, next week. None appear for the appellant. Leave this matter next week.
Much obliged.
Serial number 40. F.S. Vardarajan for appellant. Connected matter. Plus Kulkarni.
Second matter, RFA 522. The main matter, a declaratory suit.
Yes.
Filed by me is dismissed.
Suit is for declaration, one is injunction.
One is injunction with respect to one side. This is a comprehensive suit with respect to all the properties that I got under a partition deed in the family.
Yes.
Plaintiff is Narayan Gowda, of course, he is now dead, represented by his LRs.
Second matter is that main matter.
522. That's the main matter.
Yes.
The matter arises this way. That's the Chikka Kariyappa is the father. Three sons. Narayan Gowda, Veduttappa, and Subramani. There was a oral partition in the family. The partition is reduced into writing by way of a document dated 23/1984.
Yes.
Narayan Gowda gets his share in all the survey numbers that the family owned. Now, survey number 12 is the one which is particularly in dispute. Now, in survey number 12, I got my share. Likewise, my brothers also got their respective shares in that survey number.
Yes. Each survey number there is a 3 shares.
Each share. For example, in survey number 12, I got 1 acre 3 guntas.
Yes.
Likewise, my brothers have also got almost the same extent. Now, one of my brothers by name Subramani farmed certain sites in this portion of the land and sold it to certain persons over which I have no grievance. Now, after exhausting all the sites farmed in the portion of his land, he started selling portions of my property also, saying that he has farmed the sites in that portion also.
The portion is also, he says that it is belongs to him.
Firstly, he sold all the sites farmed in this portion. As I said, I have no grievance. Then he started selling portions of my land, saying that sites are in existence in that portion of the survey number also, where there is actually no. Therefore, minutes I filed this suit for a declaration that I am the absolute owner of all the suit properties by virtue of the oral partition evidenced by that Palupatti, which is marked as Exhibit D2.
Yes.
That's the learned judge accepts my case as far as partition is concerned to some extent.
Yes.
Of course, it is brought about by a Palupatti unregistered document. Nevertheless, it is acted upon in this way. As far as I am concerned, so I have moved the revenue authorities and I have obtained that's invitation order and everything in respect of my portion of the land. As far as that Subramani is concerned, let's see, obtains conversion to his portion.
Yes.
Then sells the sites farmed in that.
Anybody has denied that there is no partition.
Illa, 1 to 3 of the contesting defendants, they don't appear. 4 to 12 are the paid purchasers of the sites who sale it I challenged on the ground that those sites come in my portion of the land. Defendants 4 to 10 also remain ex parte. 11 and 13 are the contesting defendants.
They are the
They
purchaser.
don't contest the case of partition and all that. They derive title to their respective sites from Subramani. Therefore, impliedly, they have accepted the partition, and in that partition, that site has gone to the share of Subramani, or that portion of survey number 12 which has gone to the portion of Subramani. Therefore, impliedly, they have also admitted the partition. But the learned judge says the land is converted. Therefore, the RTC entries cannot be relied upon. Land is converted only as far as Subramani's portion is concerned, not my portion. My portion is 12/2. The RTC, the mediation extract everything. That's the evidences that. And on the top of it all, that's one of my brother's wife. One of my brother was Najunda. After his death, his wife Gauramma files a similar suit for a declaration in respect of the properties that her husband got under the very same partition deed. Her suit is decreed under Exhibit P34. That's following that my suit ought to have been decreed.
Decreed on the basis of that partition.
What a minute.
On the basis of the partition.
That's right. On the basis of the very same partition. Oral partition, the evidence by Exhibit P to the Palupati. That's Nanjundappa's wife gets a declaration to which Subramani's wife is also a party. That has attained finality under Exhibit P34. That's under the very same partition in respect of the properties that I get to my share. That's I file the present suit. I produce the judgment of that suit. I produce several other judgments where sites formed in my portion of the survey number are sold, where I have succeeded against those purchases. That's the court holds. It's converted land, therefore revenue entries are of no use.
Now, what is the finding regarding that other judgment in respect of the partition?
That is not mentioned. That is my grievance. Just confines himself to represent this. That I have not given a proper description. That once the Palupati gives the proper description, what more is expected of me to give by way of a complete description?
Palupati has been marked.
Palupati is Exhibit P.
There is that finding. What are the issues framed by the plaintiff? The plaintiff proves that in that partition data shows the plaintiff got the property mentioned in the para 9 of the claim.
Therefore, that's
affirmative. Court said it is affirmative.
That's not accepts my case. But property description or identification RTC will prove because it is converted is one for Subramani's portion, not my portion. Therefore, the declaration is granted. The next question is whether this site falls in my portion of survey number 12 or his portion of survey number 12. All the other judgments make it
Now
clear. In which I
now that it has been allotted there in the position, there is no suit for recovery of position.
that's it is in my portion. It's a vacant land. Possession goes with title.
No, that
Therefore, if that particular site falls in my portion of the land,
they have
that's-
not,
I am the title holder, and possession follows title in case of vacant land. So that is the principle.
no, they have not constructed any.
Therefore, the declaratory suit ಎದುರುಗಡೆಗೂ ಇರಬೇಕು ಅಂತ ಕಾಣುತ್ತೆ.
Yaru, who is your opponent? Who is that Vital Shetty? He is coming. Vital Shetty. Vital Shetty is the contesting. Is he coming regularly? ಯಾಕಂದ್ರೆ ಇವೆಲ್ಲ ಓಲ್ಡ್ ಸೂಟ್ಗಳು ಓಲ್ಡ್
No,
ಅಡ್ವರ್ಟೈಸ್
not that. I think he is not there. There is another Vital Shetty. ನಾವು ಹೇಳಿದ Vital Shetty, I think
Yes, yes.
ಸಿಟಿ ಮಾರ್ಕೆಟ್ ಅಲ್ಲಿ ಅವರ I think he is not there ಅಂತ ಅನ್ಕೊಂಡಿದ್ದೀನಿ. This Vital Shetty is different.
Counsel for the appellant is present. None appear for respondents. The last chance, please this matter next week. Yes.
Second or third.
One date.
Yes, sir. ತಾರೀಖು ಬೇಡ.
ತಾರೀಖು
ಬೇಡ.
except 3 ತಾರೀಖು you want. Please
3 ತಾರೀಖು ಬಿಟ್ಟು.
after 2 weeks. Then it will come after 3. Number 42. Number 42.
Apologies, my lord.
Yes.
We will not be able to continue with the argument. The severe throat sore.
Not well.
Not well. But I want to make this submission. Two brothers partitioned the property almost on the ratio of 75-25. Elder brother 75, younger brother 25. Minor's interest is deprived. So minor has filed a suit, who is the son of the second brother. And the suit has been dismissed. Now, my lord, the matter was argued before another bench almost for 3 or 4 occasions earlier. And the present plaintiff says the house which has been allotted to him with certain area, that a portion of it, including the house, has been encroached by the defendant number 1. That is the elder brother, because they are absentees in the location. If they vacate and give that particular area according to the partition deed, they can withdraw this appeal. It will be the settlement.
This submission was made earlier bench. I have asked my client, but he is not getting to.
What is the relationship between the parties?
Brothers.
Brothers.
Younger brother is a teacher in Subramania. Elder brother is in the native place in Kundapur. The younger brother goes to his native place for an holiday. The elder brother says, I have already drafted partition, you have to sign it. This fellow goes, I am giving you the house and that other property. This fellow goes and signs the partition deed.
Wait. Let him. I am not deciding any case. Let me understand first what is the case. Yes.
He goes and the elder brother has not made any provision for the minor son in the partition deed.
So who is that minor son?
The present appellant.
Appellant is also there.
Appellant is not a party for the partition.
How many brothers are there?
Only 2 brothers.
Only 2 brothers. He was a minor at the time.
No. Second brother's son is the appellant.
Second brother's son was there. At the
minor suit. I suit for the partition. Now, my lord, what has happened is, it is a rough sketch. ಆ ಮನೆ ಇರೋ ಜಾಗ ಲೆಫ್ಟ್ ಸೈಡ್ ಇರೋದು ಮನೆ ಇರೋ ಜಾಗದಲ್ಲಿ ನನ್ನ ಮನೆ ಇದೆ.
ಪಾರ್ಟಿಷನ್ ಅಲ್ಲಿ ಇದು ಯಾರಿಗೆ ಹೋಗಿದೆ?
ಇದು ನನಗೆ ಬಂದಿದೆ.
ಪಾರ್ಟಿಷನ್ ನಿಮಗೆ ಬಂದಿದೆ?
ನನಗೆ ಬಂದಿದೆ. ಆ ಪಾರ್ಟಿಷನ್ ಅಲ್ಲಿ ಸರ್ವೆ ಪ್ರಕಾರ ಸರ್ವೆ ಮಾಡಿ ಎಷ್ಟು ಇದೆ ಅಷ್ಟು ಮಾತ್ರ ನನಗೆ ಸಾಕು. ಐ ವಿಲ್ ಸ್ಟೇ ಇನ್ ದಟ್ ಹೌಸ್ ಅಂತ ನಾನು ಅದನ್ನ ಎಕ್ಸ್ಪ್ರೆಸ್. ದೇ ಹ್ಯಾವ್ ಟು ಕನ್ಸಿಡರ್ ಇಟ್ ಓನ್ಲಿ to the extent to honor that partition.
No, that what is that extent which is allotted to you under the partition?
That extent is around $35 cents.
ಈ ಪ್ರಕಾರ ಇದು ಮೆಜರ್ ಮಾಡಿದ್ರೆ ಎಷ್ಟು ಬರುತ್ತೆ?
ಈಗ ಅದು ಏನಾಗ್ಬಿಟ್ಟಿದೆ, ಮೇಜರ್ ಪೋರ್ಷನ್ ಆಫ್ 35 cents he has encroached. Elder brother in my absence. That also, and the house also half of the portion he has encroached, and he is dumping agricultural produce there. What is it? Let him honor that partition deed according to the partition that has taken place in the presence of a mediator, so that the matter will close.
What happened? Half portion of the house property is allotted to me. Now half portion of the house property is allotted to him. ಏನು ಅಲಾಟ್ ಆಗಿದೆ? I am in possession of that property.
ಎಷ್ಟು ಎಕ್ಸ್ಟೆಂಟ್ ಎಷ್ಟು ನಿಮಗೆ ಅಲಾಟ್ ಆಗಿರೋದು ಅವರಿಗೆಲ್ಲ? ಭಾಗಪತ್ರ
schedule.
ಅದರಲ್ಲಿ ಬಿ ಶೆಡ್ಯೂಲ್ಡ್. ಬಿ ಶೆಡ್ಯೂಲ್ಡ್.
Next paper. Next page.
ಯಾವ್ದೋ ಟೈಪ್ ಕಾಪಿ ಹಾಕ್ತಿದ್ದಾರೆ ರಿಜಿಸ್ಟರ್ ಪಾರ್ಟಿಷನ್ ಡೀಡ್. ಎಜಿಬಿಟ್ ಎಷ್ಟದ?
12. ಪೇಜ್.
ಬಿಡಪ್ಪ ಅದು ಗೊತ್ತಾಗಲ್ಲ, ಇಲ್ಲಿ ಟೈಪ್ ಮಾಡಿಸಿದಾರಲ್ಲ, ನೀನಾದ್ರೂ ಟೈಪ್ ಎಲ್ಲಿದೆ? ಯಾವ ಪ್ಯಾರಾಗ್ರಾಫ್?
ಪೇಜ್.
ಶೆಡ್ಯೂಲ್ ಹಾಕಿದಾರಲ್ಲಪ್ಪ.
ಬಿ ಶೆಡ್ಯೂಲ್.
ಸ್ಥಿರ ಆಸ್ತಿ ವಿಭಾಗ ಪತ್ರ ಒಂದು ಜಲಜಾಕ್ಷಿ.
ಒಂದು ಜಲಜಾಕ್ಷಿ, ಎರಡು ನಾಗೇಂದ್ರ ಉಡುಪ, ಎರಡು
ಶಂಕರ್ ನಾರಾಯಣ್ ಉಡುಪ. ಯಾವ್ದು
ಅದರಲ್ಲಿ ಬಿ ಶೆಡ್ಯೂಲ್.
ಯಾವ್ದ್ರಲ್ಲಿ?
ಅದೇ ಹೆಸರಲ್ಲಿ
ಬಿ ಶೆಡ್ಯೂಲ್ ಅಂತ ಎಲ್ಲಿದೆಯಪ್ಪ?
ಬಿ ಶೆಡ್ಯೂಲ್ ಅದರಲ್ಲೇ
ಜಲಜಾಕ್ಷಮ್ಮ.
ಎ ಶೆಡ್ಯೂಲ್.
ಜಲಜಾಕ್ಷಮ್ಮಗೆ ಎ ಶೆಡ್ಯೂಲ್ ಆಸ್ತಿ ಕುಂದಾಪುರ. ಆಮೇಲೆ
ಬಿ ಶೆಡ್ಯೂಲ್. ನೆಕ್ಸ್ಟ್ ಬಿ ಶೆಡ್ಯೂಲ್.
ಎ ಶೆಡ್ಯೂಲ್ ಪ್ರಾಪರ್ಟಿ ಕುಂದಾಪುರ ಶೋ ಅಂಡ್ ಶೋ. ಆ ಬಿ ಶೆಡ್ಯೂಲ್ ಸ್ಥಳದ ಎರಡನೇ ಅದು ಬೇರೆದಿದೆ. ಇದ್ಯಾರು ಕೊಟ್ಟಿದ್ದು? ಎಲ್ಲಿದ್ದಾರೆ? ಟೈಪ್ ಕಾಪಿ ಇದೆಯಾ ನಿಮ್ಮ ಹತ್ರ?
ಅದು ಎಕ್ಸಿಬಿಟ್ P8. P12 ಒಂದು.
There is no type copy. How can we read it? This cannot be. ಕೊಡಿ, ಅದರಲ್ಲಿ ಎಷ್ಟು ಅಂತ ಹೇಳಿದ್ದಾರೆ? ಮನೆ ಇಬ್ಬರಿಗೂ ಅರ್ಧ ಅರ್ಧ ಅಂತ ಹೇಳಿ. ಏನ್ ಅರ್ಧ ಅರ್ಧ ಭಾಗದಲ್ಲಿ ಇದ್ದೀರಾ ನೀವು? ಅಲ್ಲ, ಅರ್ಧ ಭಾಗ ಅಂದ್ರೆ ಮನೆ ಡಿವೈಡ್ ಮಾಡ್ಕೊಂಡಿದ್ದೀರಾ?
ಕಂಬದಿಂದ ಪಶ್ಚಿಮಕ್ಕೆ ನನಗೆ ಕಂಬದಿಂದ ಉತ್ತರ
ಮನೆ ಒಳಗಡೆ ಬೇರೆ ಬೇರೆ ಮಾಡ್ಕೊಂಡಿದ್ದೀರಾ? Then you are not in that full house. Some portion is there.
ಸ್ಕೆಚ್ ಕೊಟ್ಟಿದ್ದೇನಲ್ಲ, ಸ್ಕೆಚ್ ಇಸ್ ಡಿವೈಡೆಡ್. ನಾನು ಕೊಟ್ಟಿದ್ದ ಸ್ಕೆಚ್ ಪ್ರಕಾರ ಆ ಮನೆ ಇರೋ ಪೋರ್ಷನ್, ದಟ್ ಹೌಸ್ ಇಸ್ ಕಂಪ್ಲೀಟ್ಲಿ ಮೈ ಹೌಸ್. ಇಟ್ ಹಸ್ ಕಮ್ ಟು ಮೈ ಫಾದರ್ಸ್ ಹೌಸ್. That has come to my father's share in this alleged partition of 1986. There are 3 brothers.
No, just I want to see in the partition, entire house has been allotted to you.
That I will produce the deed, man. It is already there. I will file the typed copy.
Typed copy produced.
They produce it. They have the fair copy.
That is also there in that portion of the house.
No. Not.
If it is exclusively you, then it can be worked out. But if it is given to both,
no.
Then
ಫೈಲ್ ಮಾಡಿದೀನಿ. ಅದರಲ್ಲಿ ಟೆಂಪರರಿ ಇಂಜೆಕ್ಷನ್ ಇದೆ.
He has trespassed into my portion of property, and he has taken a temporary injunction in the Kundapur. Another suit pending disposal of this case. He says that because I have filed that suit.
See, now your suit for partition is dismissed. You are claiming an first partition or on the basis of this thing. You are saying that there was no partition earlier.
In the 1986 perm, it is unfair and unjust. Equal share has not been allotted to the brother, and his minor's interest has not been taken.
That is your case here.
Yes.
Say
Now
you are going to, you will stick on to that partition deed.
No. My submission is only this. On merit, if I have to argue, this matter will take about 5-6 hours. Instead of so, I told the client another round of litigation and another 10-15 years. What is presently there, you have it. So, the Lordship of APC, itu our
In this house, that is the newly constructed house where the defendant.
No, where it comes, it is next to this or it's.
No, the sketch I have produced is there, no, madam, my lord. In that sketch, this old house is situated.
Yes.
This entire old house belongs to my father.
Where is
as per the partition?
Where is this new house?
New house is situated, the property of the respondent number 1.
Where it will come?
Side, left side.
Here.
ಖಾಲಿ ಜಾಗದಲ್ಲಿ ಹೌದು ಅಲ್ಲಿರೋದು.
ಸುಳ್ಳು ಅಂತ ಹೇಳ್ತಾ ಇದ್ದಾರೆ.
ಮನೇಲೆ ನಿಮಗೆ ಅರ್ಧ ಇದೆ ಅಂತ ನೀವು ಹೇಳ್ತಿರೋದು ಅಥವಾ ನಿಮ್ದೇ ಬೇರೆ ಮನೆ ಇದೆ ಅಂತ?
ನಾನೀಗ ಅರ್ಧ ಮನೆ
ಅದ್ ನೋಡ್ರಿ ಅದ್ರಲ್ಲಿ ನಿಮ್ಮನೆ ಎಲ್ಲಿ ಬರುತ್ತೆ ತೋರ್ಸಿ.
ನನಗೆ ಗೊತ್ತಿಲ್ಲ ಸರ್, ಸ್ಕೆಚ್ ನನಗೆ.
Copy to him also. Let him also ask his client where its house. If he says that his house is coming in the left side, then it is entirely different. Then he can put his client's.
In a nutshell, 75% of the property is with the elder brother. 25% allotted to the younger brother. The plaintiff who has, the appellant who is before the lordship is the son of the second brother, younger brother. The plaintiff is now telling what is allotted to my father. If the encroached portion is left by the respondent number, the elder brother, I will be happy with that property and that house I will modify. Now they are not ready to vacate that and go.
No, you file a suit for declaration and possession.
No, my lord, another 10 years, 20 years.
They are not ready to.
We are absenting. No. My submission is only the.
No, yes, Mr. As per that partition deed, whatever that property allotted to him, we give him.
ನನಗೆ ಏನು ಅಲಾಟ್ ಆಗಿದೆ ಅಷ್ಟು ಮಾತ್ರ ಮಾಡಿದ್ದೀನಿ ಅಂತ ಅವ್ರ ಪೋರ್ಷನ್ ಅವ್ರ ಹತ್ರನೇ ಇದೆ, ನಾನು ತಗೊಂಡಿಲ್ಲ, ನನ್ನ ಪೋರ್ಷನ್ ಮಾತ್ರ ಇದ್ದೀನಿ. ಅವ್ರು ನನಗೂ ಕೇಳ್ತಾ ಇದ್ದಾರೆ, ಅದಕ್ಕೆ ನಾನು ಇಂಜೆಕ್ಷನ್ ಸೂಟ್ ಹಾಕಿದ್ದೀನಿ. ಅದರಲ್ಲಿ ಟೆಂಪರರಿ ಇಂಜೆಕ್ಷನ್ ಆಗಿದೆ.
I will come before your lordship with all clarity.
Then if he is denied, the remedy is to trial.
My lord,
declaration. Sorry.
Responsible and opinion appointed as the mediator. Matter can get settled. I'll just find out who is that person, mediator, who can mediate and settle.
No, at no point of time it has been referred to that mediation.
No.
Let us see. You place before the mediator what is your property allotted, and let him mediator sit together whether it is really, is there any encroachment by him. Then he can give up that as per that. See, now that both are ready to accept that partition. Now that he is saying that he has encroached some portion of your, which is allotted under partition, instead of you are filing in another suit, if he is agreed, we can settle here. That is the only point. I will refer to that mediation. Which mediator?
Mediator, KP Vasudev Rao.
Yes, when do you want? We'll have it. We both are agreed. Sit together and decide whom it has to be referred. We'll refer it.
Number of cases.
Yes, you also.
He goes to the KP Vasudev Rao.
KP Vasudev Rao, you ask your client and counterpart if they are ready. If they are not ready, if you have any persons, before that you also convey him. If both are agreed, come and tell me on 30th.
Please.
Not come on 30th and again disputing that no, it is not ready. You both has to be decide one person and come. On 30th, I will refer it.
Please.
Yes, please this matter on 30th at the request of the parties.
Number 50. ಬರ್ತಾ ಇದೆ.
Yes, for the appellant. This matter. Okay.
Next, Babu, Sri Krishna.
Appellant is the advocate, my lord. In money recovery, my lord. Respondent is the bank. Including fees, legal fees also is recovered by, my lord. I make instruction to speak, my lord.
But what has happened to suit is secret. Why? What ground they have filed in a suit for recovery? Because the plaintiff bank is agreed with the cost. Plaintiff bank against the defendant for recovery of sum of 1 lakh with operate for the date of the suit till the date of the cost. Why they have for housing loan facilities and plaintiff bank considering that request and sanction. Housing loan he has taken. Yes, it is not related to any professional business.
It also is,
Maybe he is in this thing. He has taken housing loan. He has not paid.
make instruction.
Whether he has completely paid that installment or whether he is ready to settle.
Please.
Request of counsel for the appellant. Leave this matter next week.
Please.
Which is your matter, Mr.
Sorry, I was not here. That side is not here.
Now then, serial number.
Was here. What then to final hearing, second matter. And for appellants.
Other side bandi. No, now that amendment of cost title ಮಾಡಿಲ್ಲ ಅಂತ ಇದೆಯಲ್ಲ.
ಮಾಡಿದ್ದೇನೆ amended cost title ಎಲ್ಲ.
ಅಲ್ಲ, you have not amended that appeal memo. Other side as present when second time it is called. You are not there, then
Sorry.
urgent. See, if he is not amended, you amend it.
Parties will have built time.
So non-amendment of cost title in regarding this is as a non-filing of an SNF. ಮಾಡಿದಾರಾ?
Appellant number 5.
Non-amendment of cost title of this is appellant number 5.
ಮಾಡಿಲ್ಲ ಸರ್.
ಅದನ್ನ ಮಾಡಿ ಅಮೆಂಡ್ಮೆಂಟ್ ಮಾಡಿಲ್ಲ. ಮಾಡಿ ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಹೋಗಿದೆ. Yes, you do it.
Latest.
Yes.
Sorry, man. Today morning I have taken adjournment Monday. Interim order is existing till today. Sorry.
Order, huh? It is already signed. 2:30, Government Council for appellant has submitted that. Requested for extension of interim order granted earlier. Interim order granted earlier, if any, extended till next week.
Sorry.
2:30. ಅದು ಯೂತ್ ಪಾಸ್ಪೋರ್ಟ್ 2:30. ಹೇಳ್ಬೇಕಾಗ. Yes, regarding that change of classification, we are directed in the administrative stage will this thing. If both are have no objection,
Absolutely no. Please. The plaintiff's appeal against an order passed by the trial court. An application made under Order 7, Rule 11. Treating it as an application under Rule 10 and returning the plaint for want of territorial jurisdiction. The suit, my lords, is one filed for infringement and passing off. The mark in question is Natraj. Undisputed position, my lords, is that I am using this mark since 1956.
What is that Natraj pencil?
No, my lord, this is a silver leaf which is used on sweets. If I may show your lordships the two marks. The one in green is of the plaintiff appellant and the one in red is mine. Then it wins mine.
The issue is not that infringement and
No, it's territorial jurisdiction.
Only jurisdiction point.
Yes. Not on merit.
Not on merit.
Not on merit.
Just I want to usually Natraj means a classic
Pencil. Yes, yes. And in fact, that has been subject matter of many judgments also.
Yes, yes.
But here, my lords, the mark is identical. The product is identical. The pricing is also identical. And I have a registered mark, which I am using since 1956. My registration was 1978. Now, on this basis, my lords, a suit was filed before the City Civil Court at Bangalore, both for infringement and passing off. Lordships, get the prayer at page 74. Prayer is to restrain the defendants from passing off. Page 74, my lords, of the appeal papers. Yes. Prayer A is for passing off, my lords, in respect of Natraj. B is in respect of infringement. Infringing, and then, my lords, destruction of the marks, infringing products, rendition of accounts, etc. Now, my lords, the suit your lordships will find. The cause title note discloses that the parties are based in Uttar Pradesh. But I will show your lordships from the averments in the plaint that the infringing product has been sold in Bangalore. And that is sufficient to constitute, my lords, the cause of action for this honorable court to entertain the suit.
The sold in Bangalore is enough.
Yes, my lords.
No, sold in Bangalore by that defendant or some other person?
Both plaintiffs and defendants.
Both are.
And invoices are produced. I'll show your lordships the invoices. Both plaintiff and defendants are selling, my lords, in Bangalore.
You have an office here for this thing?
No, there is no office. There is no office.
Yes.
It is sold, my lords, basis orders placed on us by wholesalers. So the invoice is raised from Saharanpur, dispatched and sold, my lords, to the wholesalers in Bangalore. So the actual sale and use of these products takes place in Bangalore.
Use of the products, so naturally it will take in Bangalore because the buyers are here. How it has been sold, the issue, whether They have to go to your place and purchase and using here.
No, my lords, no. That I've made the averment in the
Yes.
plain.
Yeah,
No, my lords, for it, that in fact then becomes a matter of trial.
Yes.
In an order 7 rule 11,
Yes.
all that the trial court has to see is whether I have made an averment regarding the cause of action arising here. Now, my express case in the plaint is that the sale of the products is taking place in Bangalore.
Yes.
In support thereof, I have produced invoices of the defendant to show that the sale has taken in Bangalore. Once that is the case, my lords, the jurisdiction is established. It cannot be then the subject matter of an order 7 rule 11 application for rejection of the claim.
It may be the issue as a one of the issue.
It could be a preliminary issue at best. Because then, my lord, both parties can lead evidence on the preliminary issue. Defendant's written statement and documents can be taken into account. Now, the trial court has made an error in my very respectful submission by following judgments under section 134A and B of the Trademarks Act.
Yes.
My lords, A and B is a special remedy where a plaintiff can sue where the plaintiff resides.
Yes.
The remedy under the CPC under section 20C is independently available.
Yes.
So the trial court has misdirected itself on A and B
Yes.
and rejected the claim. It has not even gone into the question, my lords, as regards sale by the defendants. So may I first show your lordships the averment in the plain,
Yes.
and then go, my lords, to the section 134.
Yes.
First, my lords, please take page 72.
Yes.
Which is the cause of action paragraph, para 52 and 53.
Yes.
The cause of action arose in August 2022 when the plaintiffs first became aware
Yes.
of the defendant's use and application for registration of the trademarks SV Natraj
Yes.
and Shri Natraj.
Yes.
The cause of action has further arisen on each and every day before and after August 2022, whenever the defendants have made any use of the aforesaid trademarks.
Yes.
Suit is within time. Now 53. Both the plaintiff's original products and the defendant's duplicate products bearing the aforesaid infringing marks are sold within the jurisdiction of this honorable court, and as such, both the plaintiffs and the and as such, the plaintiffs and defendants are both carrying on business within the jurisdiction of this honorable court. Furthermore, by virtue of sales of the defendant's products within the jurisdiction of this honorable court, the cause of action for passing off an infringement has also arisen within the jurisdiction of this honorable court. Therefore, this honorable court has jurisdiction to entertain, try, and determine the suit under the provisions section 20 CPC. Now, this averment that the defendants are selling, my lords, within the jurisdiction of the Bangalore City Civil Court is not denied in the written statement. Please take the WS. In fact, my lords, the trial court at an order 7 need not or cannot look into the written statement. This averment is all that it needs to see. And I have produced invoices. They are in the paper book, lords. I will take your lordships to it. But I want to show your lordships in the written statement also, there is no denial of sale. Page 79. Please come to. Page 89.
Yes.
Para 36. Regarding para 53. It is stoutly denied that the defendants are selling duplicate products bearing the infringing mark within the jurisdiction of this honorable court. On the other hand, neither there is any infringement of trademarks, as there is no infringement or copyright. The suit is not maintainable, as this court is having no territorial jurisdiction or otherwise. It is stoutly denied that both plaintiffs and defendants carrying on business within jurisdiction of this honorable court. Please mark this. Mere sale of products will not confer the right to institute a suit before this honorable court. On the other hand, as held by the Honorable Supreme Court, neither plaintiffs and defendants are having head office or subordinate office, and the court will have jurisdiction. Only subordinate office of the defendants is within the jurisdiction of the honorable court. That is not the law, my lords. The office of the defendant is irrelevant for the purpose of cause of action for infringement and passing on. The cause of action is where is the infringement happening? or where is the deception taking place? The tort of passing off arises where the deception takes place. Now, they do not expressly deny the sale of the product in Bangalore. And even the application under Order 7 filed by them, which your lordships get at page 115, the averment is reiterated. 115, lords, is the application under Order 7, Rule 11. A and D, kindly see para 9. Mere selling of the Natraj silver leaves in Bangalore, Chennai, Hyderabad, or elsewhere in India will not confer jurisdiction to this honorable court. So the tacit admission is that sale is taking place. They proceed, my lords, in their application on the basis that parties do not have offices in Bangalore. And since there is no office in Bangalore, there is no cause of action. But that is not the law, my lords, as I will presently show your lordships.
I think trial court has missed to consider under section 20 of the 6.
20 consider agila or 134 mein hogidare.
Allah, first paragraph says, laying on this court judgment, wrongly, first paragraph itself held that this court has held that 20 is not applicable. That is the judgment wrongly considered by the this thing. You see that. Reasoning.
Para 5, my lords, page 14.
Yes.
Plaintiffs have filed the present suit against defendants for infringement and passing off. Then 6, plaint averments disclose that the defendant and plaintiff are claiming the trademark through their ancestors. The cause title of the plaint sufficiently disclose that both plaintiffs and defendants are residents of Saharanpur. The entire plaint averments nowhere disclose that the parties to the suit is having any branch office at Bangalore, at Barodela, or within the territorial jurisdiction of this court. Of course, the plaintiff has produced certain sale invoices, kindly mark this, issued to the traders at Bangalore. But the invoices have been issued by Raja Traders of Saharanpur, Uttar Pradesh. The said sale invoices of the plaintiff is issued at Uttar Pradesh. Similarly, the plaintiff also produced the copies of the sale invoices issued by D1 under the name of Sham Traders. The said Sham Traders is also situated at Saharanpur. Therefore, whatever transactions carried out by the defendants is from Saharanpur of Uttar Pradesh. It is relevant to note that none of the...
That you see that para 10.
Para, I'm grateful. Therefore, in view of the aforesaid provisions, the territorial jurisdiction has to be considered. The Honorable High Court, in a decision relied by the plaintiff reported in so and so, has held that as per section 134(2) of the Trademarks Act, section 20 is not applicable for this. Is not the view, my lords.
That the basic conception of that trial court, that perception itself is not correct. That
Supreme Court, clear word, 2015 judgment, I have relied upon that judgment, followed by the Delhi High Court, clearly told section 20, when applicable, is a exception to 134. Then both, that's clearly, just part of that judgment.
Allah, that said that it is applicable.
Also, when the office or the subordinate office in the jurisdiction of the court and transact, then only. I just pass on this judgment.
Just let him complete.
Yes, yes, lords. Now, so the trial court has now, lords, your lordship, seen at para 10, proceeded on the basis that section 20 is inapplicable to section 134. This is a patent error that the learned trial judge has committed. It refers at para 11, my lords, to the judgment in Ultra Homes, which I will show your lordships holds otherwise. And ultimately, at para 14,
yes,
holds that since the offices are in Saharanpur,
where is that judgment have you produced?
yes, my lord, we have made a compilation for your lordships. May I show your lordship section 134 before going to the case law? Yes, that's true. Please see 134 of the Trademarks Act. 134.
Yes.
Suit for infringement, etc., to be instituted before the district court. No suit for the infringement of a registered trademark, or B, relating to any right in a registered.
So senior counsel will go one by one. First, your argument is that court cannot go into all these things when it is under Order 7, Rule 11.
Please.
On that, you complete that, then we'll go to that.
Very
Other
well.
aspects.
Very well, my lords. In that regard, my lords, your
First,
lordship.
you said that since there is a pleading in that line to show that cause of action is arises here,
Lordships.
that itself is general. It cannot be rejected the plaint under Order 7, Rule.
Rule 11. And in that regard, my lords, in my case compilation that I have now placed, the judgment at serial number 9, my lord, settles the position. Page 176. (176), my lords.
Yes.
At
If this is upheld, I need not go into that other aspects. If I upheld this, if I given a finding on that, nothing is left for the trial court to decide as a preliminary issue. Therefore, first we'll decide this. If this contention has been upheld, then I need not go to that other.
Quite so, my lord. Now please see para 12. In fact, at para 11 onwards, the discussion on Order 7 is made.
Yes.
Under Order 7, Rule 11 of the court has jurisdiction to reject the plaint where it does not disclose. Disclose meaning on a reading of the plaint. Para 11.
11.
Lordships.
Yes.
Does not disclose a cause of action where the relief claim is undervalued and the valuation is not corrected within the time fixed, where insufficient court fees is paid, etc. Then rejection of the plaint in exercise of powers under Order 7, Rule 11 of the court would be on consideration of the principles laid down by this court. In Arvindanandam, this court has held that if on a meaningful, not formal reading of the plaint, it is manifestly vexatious and meritless in that sense of not disclosing a clear right to sue, the court should exercise its power under Order 7, Rule 11. Then in Ruplal Sethi, this court has held that where the plaint discloses no cause of action, it is obligatory upon the court to reject the plaint as a whole under Order 7, Rule 11 of the court. But the rule does not justify the rejection of any particular portion of the plaint. Therefore, the High Court therein could not act under Order 7. I'll skip this, take your lordship directly to para 12 now. After referring to the case law, from the aforesaid, it is apparent that the plaint cannot be rejected on the basis of the allegations made by the defendant in his written statement or in an application for rejection of the plaint. The court has to read the entire plaint as a whole to find out whether it discloses a cause of action. And if it does, then the plaint cannot be rejected by the court exercising powers under Order 7, Rule 11 of the court. Essentially, whether the plaint discloses a cause of action, kindly mark this, lords, is a question of fact which has to be gathered on the basis of the averments made in the plaint in its entirety, taking those averments to be correct. A cause of action is a bundle of facts which are required to be proved for obtaining relief, and for the said purpose, the material facts are required to be stated, but not the evidence, except in certain cases where the pleadings relied on are in regard to misrepresentation, fraud, willful default, undue influence of the same nature. So long as the plaint discloses some cause of action which requires determination by the court, the mere fact that in the opinion of the judge, the plaintiff may not succeed cannot be a ground for rejection of the plaint. In the present case, the averments made in the plaint, as has been noticed by us, do disclose the cause of action, and therefore the High Court has rightly said that the powers under Order 7, Rule 11 of the court cannot be exercised for rejection of the suit filed by the plaintiff. Similarly, this answers, my lord, the question of Rule 10 also. Similarly, the court could not have taken the aid of Section 10 of the code for stay of the suit, as there is no previously instituted suit pending in a competent court between the parties, raising directly and substantially the same. Lords, para 12 settles it.
What is the position of law regarding the return of plaint? Because your order is passed under the return of plaint.
Yes, the principle would be the same, my lords. If your lordship see
any judgment on that point, you have seen that how that it has to be, whether there should be an preliminary issue or assured it can be decided.
No, but that's the judgment relied upon by the trial court. Delhi judgment clearly says that even though a rejection is found, it has to be returned.
No,
Jurisdiction.
written, now that court has exercised the power under that Rule 10, Order 7, Rule 10. Because return the plaint, rejection of the plaint is different. Rejection of the plaint, what you said is correct.
Yes.
If that plaint has make out any prima facie cause of action,
Yes.
court has to try the
Reject.
suit.
Yes, please.
But here, return of the plaint, it is the same.
The same principle, notes. I will check once again if there is a judgment dealing both with 11 and 10.
Yes.
But in my respectful submission, the criterion is the same as far as cause of action is concerned.
Yes.
Under Rule 11, Lord, there is A to F.
No, cause of action, rejection of the plaint, is that
non-existent.
Non-existent.
I'm great.
Returning the plaint means you have still having a right, you have to be placed before the proper court.
Appropriate court.
Yes.
There, my lords, under 10, it can again only be returned if the court finds, my lords, that the suit should have been instituted in some other court. So it is inbuilt in 10. Just see the language of 10, my lords. Subject to the provisions of Rule 10A, the plaint shall, at any stage of the suit, be returned to be presented to the court in which the suit should have been instituted. So, should have been instituted necessarily means that the court before which the suit is instituted does not have to.
Rule 10.
Please.
Order 7. 7th rule.
Yes, yes.
Subject to the provisions of Rule 10A,
Yes.
the plaint shall at any stage of the suit be returned to be presented to the court in which the suit should have been instituted.
Yes.
So this necessarily is a determination of jurisdiction.
I am saying that here it need not be that he need not see that written statement or only on the plaint. All judgment which you have caused that it is under the rejection of the plaint. Even Supreme Court number of judgments says you see the plaints.
I understand what has fallen from your lordships.
Yes.
But my lords, their very application was under 11.
But what has excised the power?
Has excised under 10.
Then therefore, maintainability also this court has answered
By saying that it is under 10. I'm aware.
Yes.
Otherwise, it would be an RFA.
RFA.
But offhand, I don't have a judgment. I'll have to examine that and come back.
That is the point you have
I
to-
understand.
Now that what is the procedure? Because if here is procedure is different, then I have to see that cause of action, whether it is.
What is lordships? Whether the principle of 11 will also apply to 10.
Then yes.
Because I'll do a little study and come back to you.
Just I'll pass on two judgments, my lord, which is one is relied upon by me and one is cited by the trial judge.
You pass on to that to senior counsel also. We'll have it on tomorrow.
Yes.
Judgment.
Yes, first judgment, my lord.
10 mil Allah. It's not on order 7, rule 10.
Yes, my lord, I have taken lordship. Indian Performing Rights Society Limited. In that manner, I straight away take a lordship too.
It's serial number 1 in my compilation. Yes, both these judgments are in my compilation.
It is cited by me, based on which I have prepared the application.
Because trial court has not discussed all these things.
Discussed by everything is discussed. I will take a lordship.
Paragraph you want to read, Mr. Venkatesh. Now that you want this, you have made a mark for me and for you.
Sorry.
Yes, you take this.
Yes,
Because in most of the judgment which you and I have across, you can see that then even then application under order 7, 11,
yes.
Even that rule 10 court has considered and discussed regarding the jurisdiction. Said that on the point which you have raised, that it has to be tried as a preliminary issue. In return of the plaint also.
Yes.
I think most of the cases.
On merit, it cannot do it. One jurisdiction, like inherent lack of
Court
jurisdiction
said
is there.
that jurisdiction has to be decided.
Yes.
Yes.
The point you have raised that it cannot be tried as a preliminary issue. In
Lords, my first submission is that if the plaint discloses cause of action, an application
that is
cannot.
true. Under order 7, rule 11, it is
11. Then comes the question of 10.
Yes.
Even to return the plaint, When the averment in the plaint discloses the cause of action, the principle remains. Can the trial court then say under 10, I will return? It has to necessarily then adjudicate the question of jurisdiction. And many times, my lord, jurisdiction is a mixed question of fact and law. So
Now here question is whether court can see that written statement and other documents.
Lordships.
Because in the judgment of that Order 7, Rule 11, Supreme Court said you can't see it only on the claim.
Whether the same principle applies.
Is applicable to here. Because some of the cases court has seen that subsequently the documents have been used. Even that some of the cases the Delhi High Court said even that using the third party platform to sell the product where product will be sold, it is also cause of action.
Quite so. In fact, interactive websites have been
It is not that only that belonging to the plaintiff or defendant. Their product has been sold in that either in that Amazon. The product should be available in that forum state. Then only it cause of action.
From Big Banyan's case, onward, the Delhi High Court Division Bench has consistently held that where there is purposeful availment, that is the test, where a party avails a particular jurisdiction by enabling a sale online, that is sufficient to constitute jurisdiction.
No, that's you have to show that their product is available in the Bangalore and online.
Physically, I produced invoices.
No, whether it is sold in that Uttar Pradesh or here.
Uttar Pradesh.
Wait.
Those are matters of trial. The
Wait, Venkatesh, very. No, it was very. We are not disagreeing. I want to know that.
Just getting to the matter. The invoices clearly show, my lords, that the purchase takes place in Bangalore. And these are purchases made by wholesalers. I have produced my audited returns to show that bulk of my business as a plaintiff also is in Bangalore. And from the time the defendant has started infringing the mark in 2021, 22, my sales have slumped by about 80 to 90%. So all of that material shows that, my lords, the infringement and the violation of my right is taking place here. Now, beyond that, it becomes a matter of evidence. Either the trial court can frame a preliminary issue and ask the parties to lead evidence on the preliminary issue, if it considers it to be a mixed question of fact. Otherwise, it will have to be a regular issue. And after evaluating the evidence, answer the question of jurisdiction.
That's where I have struck whether it should be a preliminary issue or it can be decided threshold.
Quite so. Then I'll do a little study on Rule 10 and
you see that judgments of number of judgments of Delhi.
Yes.
There and all they have taken that as like in a trial. They have decided. See in that V-Guard, you see, V-Guard, they have decided that even if it is sold in that third party platform, that is Amazon, see the Bangalore, then said
it is sufficient. But here, the trial court has not gone into any of these questions. The trial court has only read 134A and
no,
B.
that's what the first preliminary. All that part of cause of action is arises or not, it is issue will come only in that section 20. Trial court has excluded
20.
That's what I'm seeing, that I can, instead of giving all these findings,
send it back to the trial court.
You first convince on that.
Yes. Now on 20, my lords, I'll show your lordships from.
No, you see that para 20 of the trial court judgment.
Correct finding, my lord. I will take your lordship, relied upon those two judgments.
No, that you see that para 20.
Yes, my lord.
Section has first decided whether 20 is applicable or not. Said that 20 is not applicable.
20 is
then
not,
it comes to that 134.
No, my lord. 20 is not applicable because of that proviso to section 20.
I'm
Yes,
grateful.
I will take your
Now I'm grateful. My friend has come to the proviso.
Yes.
That narrows down the scope, my lords.
Yes.
Just see 134. But 134 of the Trademarks Act.
Yes.
Suit for infringement to be instituted before district court.
Yes.
No suit for the infringement of a registered trademark or relating to any right in a registered trademark, or C, for passing off arising out of the use by the defendant of any trademark which is identical with or deceptively similar to the plaintiff's trademark, whether registered or unregistered, shall be instituted in any court inferior to a district court having jurisdiction to try the suit. Now, in respect of A and B, please see subsection 2. For the purpose of clause A and B, that is for infringement of subsection 1, a district court having jurisdiction shall, notwithstanding anything contained in the Code of Civil Procedure or any other law for the time being enforced, include a district court. Include, which means it is an additional remedy. Include a district court within the local limits of whose jurisdiction at the time of institution of the suit or other proceeding, the person instituting the suit or proceeding, or where there are more than one such persons, any of them actually and voluntarily resides or carries on business or personally works for gain. So subsection 2 is an additional remedy for the benefit of a plaintiff.
Section 134 itself is an additional remedy to the section 20.
I'm so grateful. I'm so grateful. That's the short point. Now, if, and that is how the courts have consistently.
Some of the judgment also have seen that.
Yes, it's in my entire compilation.
Let him see that he is citing that judgment.
Yes,
which is
I will take a lordship to that.
So, my lords, I too have placed that judgment of the Honorable Supreme Court has been rendered in the context of 134A and B.
Now that you answer on that point, then we'll see that whether section 20 has to be excluded or included.
Please,
Yes.
please.
That will, if that has to be convinced me, then I need not go to that other point.
Quite so. So now my lords have seen that 134(2), my lords,
Yes.
is an additional remedy created in favor of a plaintiff.
Yes.
Now, please return to section 20 of the CPC. Other suits to be instituted where the defendants reside or cause of action arises. And my suit is under 20C, subject to the limitations aforesaid. Every suit shall be instituted in a court within the local limits of whose jurisdiction A and B relate to the defendants carrying out. C, the cause of action wholly or in part arises. Now, as per my averment in para 53, the cause of action within the meaning of section 20C has arisen within the jurisdiction of the court in Bangalore. In support of that pleading, I have also produced invoices. That is sufficient, my lords, to constitute jurisdiction for the trial court to entertain the suit. Now, what the trial court has done in the given case, as your lordships have rightly observed, is to confine itself to a reading of 134A and B. Yes. And hold that section 20 CPC is not applicable. That is a patent error, as I will demonstrate, my lords, from the case law that I have placed before your lordships. It includes the two judgments my friend has also relied on. Please take the compilation. The trial court has relied on the judgment at serial number 4. I will first show your lordships that. Ultra Homes. Yes. Page 59. This is a division bench judgment of the Delhi High Court. Please come to para 13.
This judgment which relied on 2010 3 KLJ.
Both of those judgments. Yes. I'm just getting. Ultratech is on this. Ultra is also referred. Yes. By the trial court. The order. Just see para 11, lords.
Yes.
In this context, it is useful to refer to the subsequent decisions rendered on this aspect.
Yes.
Ultra. Now, please see Ultra. Para 13. By virtue of the Supreme Court decision in Sanjay Dalia, which is the Supreme Court judgment my friend relies on, this deeming provision contained in the explanation in section 20 of the code has been read into section 134 of the Trademarks Act and section 62 of the Copyright Act for the purpose of isolating the place where the plaintiff can be said to be reside to carry on business. This is for the plaintiff. It will be noted that though the expression carries on business is used in all the three provisions, 20 of the Code, Section 134 of the Trademarks Act, and Section 62 of the Copyright Act, the deeming provision contained in the explanation in Section 20 of the Code has not been expressly incorporated in the other two provisions. But the Supreme Court has, in the said decision, given the expression carries on business used in relation to a corporation in the context of a defendant in Section 20 of the Code the same meaning when it is used in relation to a plaintiff under Section 134 and 62. It would be instructive to note the following observations of the Supreme Court in the said decision. Notes the judgment is extracted. I may read to your lordships. Para 18 of the Supreme Court judgment, internal 18 at page 68. On a due and anxious consideration of the provisions contained in Section 20 CPC, Section 62 of the Copyright and Section 134 of the Trademarks Act, and the object with which the later provisions have been enacted, it is clear that if a cause of action has arisen wholly or in part, where the plaintiff is residing or having its principal office or carries on business or personally works for gain, the suit can be filed at such place. The plaintiff can also institute a suit at a place where he is residing, carrying on business or personally works for gain, dehors the fact that the cause of action has not arisen at a place where he or they are residing or any one of them is residing, carries on business or personally works for gain. However, this right to institute suit at such a place has to be read subject to certain restrictions, such as in the case of the plaintiff residing or carrying on business at a particular place, having its head office, and at such place, cause of action has also arisen wholly or in part. The plaintiff cannot ignore such a place under the guise that he is carrying on business at other far-flung places also. The very intendment of the insertion of provision in the Copyright Act and the Trademarks Act is the convenience of the plaintiff. The rule of convenience of the parties has been given a statutory expression in Section 20 as well. The interpretation of the provisions has to be such which prevents the mischief of causing inconvenience to the parties. This is all in the context of the plaintiff's right to sue, my lords. The special right of a plaintiff. The intendment of the aforesaid provisions inserted in the Copyright and Trademarks Act is to provide a forum to the plaintiff where he is residing, carrying on business or personally works for gain. The object is to ensure that the plaintiff is not deterred from instituting infringement proceedings because the court in which the proceedings are to be instituted is at a considerable distance from the place of their ordinary business. The impediment created to the plaintiff by Section 20 CPC of going to a place where it was not having ordinary residence or principal business was sought to be removed by virtue of the aforesaid provisions of the Copyright Act and the Trademarks Act. Where the corporation is having ordinary residence for principal place of business and cause of action is also arisen at that place, it has to institute a suit at the said place and not at other places. The provisions of Section 62 of the Copyright Act and 134 of the Trademarks Act never intended to operate in the field where the plaintiff is having a principal place of business at a particular place and the cause of action has also arisen at that place so as to enable it to file a suit at a distant place where its subordinate office is situated, though at such place no cause of action is arisen. Such interpretation would cause great harm and would be juxtaposed to the very legislative intendment of the provision so enacted. In our opinion, in a case where the cause of action has arisen at a place where the plaintiff is residing or where there are more than one such persons or any of them actually voluntarily resides or carries on business or personally works for gain, would out the jurisdiction of the other place where the cause of action has not arisen. Please mark this. Though at such a place, by virtue of having a subordinate office, the plaintiff instituting a suit or other proceeding might be carrying on business or personally works for gain. Now, this is considered at para 14, which the trial court has followed. It is evident from the above observations that the interpretation given to the expression carries on business in the context of a defendant under Section 20 of the Code has also been employed in the context of a plaintiff under the said sections 134, 2 and 62. Thus, please mark this. In addition to the places where suits could be filed under Section 20 of the Code, the plaintiff can also institute a suit under the Trademarks Act and the Copyright Act, as the case may be, by taking advantage of the provisions of Section 134 and Section 62 respectively. So, my lords, the judgment of the Supreme Court in Sanjay Dalia and the judgment in this Ultra Home clearly recognize that 134 is an additional right for the plaintiff. It does not take away, my lords, the right under section 20. In fact, lords, 134 was inserted to give a special right to a plaintiff who has a registered trademark to be able to sue where the plaintiff resides. Now, the Supreme Court in Sanjay Dalia clarified that, saying plaintiffs cannot abuse that special power and sue wherever they have some office. They must also show some cause of action. But this is a case where I have sued, my lords, where the cause of action has arisen. I am not invoking 134A and B read with 134.2. I am also not based here. In fact, this argument would arise if I brought a suit in Saharanpur saying the plaintiff is registered in Saharanpur. It would be more convenient for me to sue in Saharanpur. I have not sued there and sued here because the predominant sales take place here. And that jurisdiction under section 20C continues to inure, my lords, to any suit where the cause of action arises. The trial court, with great respect, has read it the other way. It has read 134 to mean an exclusion of section 20C. When in fact, my lords,
134 is an additional rights given to that
plaintiff.
In addition to that section 20.
20C.
Court has said that it is your rights has been given only under 134.
In fact, lords, my suit is both for infringement and passing off. Now, under 134, the special right is only for infringement. A and E.
It is only for infringement.
Please, for passing off, subsection 2 has no application. For passing off anyway, my lords, 20C will apply. So,
passing off is also 134 applies.
Lords, 134.2 does not.
2 is not.
Lords, 134.1 only says that for infringement or passing off, the suit shall be instituted
in the district
court. That's all. But where it is under A or B, please see 2 again. For the purposes of clauses A and B of subsection 1, district court having jurisdiction shall, notwithstanding anything contained in the CPC or any other law for the timing in force, include a district court within whose local limits the person instituting the suit voluntarily resides. So it's a special right created for infringement because, lords, passing off is for an unregistered mark. But where a party takes the trouble to get a special registration under the Trademarks Act, the special rights under section 27 for infringement flow, then this act created a convenient
additional rights has been given.
It can never mean that the right available under section 20C of the CPC was taken up. And that is what, my lords, the series of judgments have held in the same compilation. Now, please see a judgment of our court, my lords, on the point, which is INTAS at serial number 5, page 7. I'm sorry. INTAS was followed. Please come to, my lord, serial number 6, page 81. Lord, this is the judgment in Zeno Davidoff. Please come to page 111. The very Lordships have it. Great. Yes. Page 111. Yes. The very contention now raised in the instant case was the subject matter for consideration before the High Court of Delhi in the case of Intas Pharmaceuticals, yes, where it is held as follows. Now, coming to section 20 of the code, a perusal of the same makes it manifest that it is possible to invoke the jurisdiction of the particular court if the dependents or any of the dependents resides or carries on business or personally works for gain within the jurisdiction of the said court. When the Trademarks Act was enacted, the legislature was fully conscious of the fact that Section 20 of the CPC provides for a forum and place in which a suit is required to be instituted. Despite the said fact, Section 134 of the Trademarks Act was enacted, and while enacting the said provision, which was in addition, please mark this, which was in addition to the provisions of the Code of Civil Procedure, the legislature specifically included the non-obstante clause, which states notwithstanding anything contained in the CPC. Therefore, in our opinion, in view of the inclusion of the aforesaid expression in the statutory provision, notwithstanding anything contained in the CPC, the provisions of Section 134 of the Trademarks Act shall have to be read in addition to the provisions of Section 20 of the Code of Civil Procedure. The aforesaid position is also made clear and reiterated by the Supreme Court in the case of Doda House. In para 19 of the said judgment, the Supreme Court held thus: cause of action, as is well settled, is a bundle of facts which are necessary to be proved in a given case. Cause of action, it is tried, if arises within the jurisdiction of the court concerned, empowers the court to entertain the matter. Determination of territorial jurisdiction of a civil court is governed by the provisions of the CPC. Now, after referring to this, Lords, please come to para 24 of the judgment of this Honorable Court at 116. Plaintiff has alleged in the plaint at paragraph 38 of the present suit to the following effect: the defendants actually and voluntarily reside and carry on business personally and through their agents within the territorial jurisdiction of this Honorable Court. Moreover, the defendants are offering for sale the counterfeit shirts bearing the trademark name Davidoff through the infringing website davidoffindia.com. Any person accessing the defendant's website can place orders for the trademark Davidoff. This Honorable Court also has jurisdiction under Section 134 of the Trademarks Act, where the plaintiff's goods are available freely. Cause of action is a bundle of facts which is required to be proved in a given case. Cause of action, if arises within the jurisdiction of the court concerned, it empowers that court to entertain the suit. In the judgment rendered by the Honorable Supreme Court in the case of Doda, referred to two orders, namely of the Allahabad High Court and the Delhi High Court, which came up for consideration. In Doda's case, the plaintiff, who was carrying on the business of sweet meat, sought for injunction. I think I can skip this. Take your lordship to 27. Likewise, PM Diesels filed a suit at the High Court of Delhi against Patel Field Marshal and others, claiming relief of perpetual injunction, restraining the infringement of its trademark, copyright, etc., and for redaction of accounts. An application for injunction was rejected on the ground of lack of territorial jurisdiction, and the division bench, while examining contentions raised by the plaintiff, held that the Delhi High Court had territorial jurisdiction, since A, it was a composite suit, mine is also a composite suit, and the defendant had applied for registration of its trademark at Delhi. Thus, these two judgments came up for consideration for the Honorable Supreme Court, and after examining various provisions of the Copyright Act, Trademarks Act, it came to the conclusion in Doda's case that the High Court had positively arrived at a finding that infringement complaint of primarily was under the Trademarks Act and not under the Copyright Act. In the instant case, please mark this, when facts are examined by scrutinizing the plaint averments, it would emerge that the plaintiff had specifically alleged that the defendant is selling similar products at Bangalore as that of the plaintiffs. And the plaintiff has also alleged its products are being sold at a number of outlets at Bangalore. And identical issues have been examined by the High Court of Delhi in Intas Pharmaceutical, referred to Supra, has clearly held that the case in Doda was inapplicable to the facts of the case. Principle laid down in Intas Pharmaceuticals are squarely applicable to the facts of the present case, prima facie. Since the suit in question has been filed at Bangalore, it would be maintained. And as per Section 20, Clause C of the CPC, when the cause of action arises either wholly or in part at Bangalore. In the present case, the plaintiff has specifically contended that the defendants voluntarily and actually reside and carry on business within the territorial jurisdiction of Bangalore. And such, the Bangalore court also has jurisdiction to try and entertain the suit prima facie. Please mark this, Lord. Since the defendant is also claiming to sell its products at Bangalore, as admitted by it in its written statement, which, however, please mark this, would be an issue triable during the course of trial. Hence, conclusion arrived at by the trial court to deny consideration of the plaintiff's prayer for grant of temporary injunction at the initial stage is erroneous. This judgment squarely covers the question that 20C is an additional remedy. And once there is an environment that you are selling.
That is second point.
Yes.
If I convince on that, it has to be trial court to decide.
Decide.
I don't want to give any finding on that.
I quite understand.
Otherwise, I can decide here also that whether jurisdiction. Let us see how he will answer.
Before I conclude, I just tell your lordships from this compilation, there is also the judgment at serial number 7, 151, which is a judgment of this honorable court. This is the judgment, my lords, that has been relied on by the trial court. It seems to have read the head note. Clause head note B.
Head note is also wrongly corrected.
Yes, that's the mistake made. In fact,
that is not that actual.
That is not the ratio. So grateful. This was a case, whereas 7.
There it is. Section 20 of the Civil Procedure Code. Is that paragraph 1?
Para 18, my lords. Section 134 of the Trademarks Act empowers the plaintiffs to file a suit for infringement before the district court. Clause 2 of the said section includes a non-obstante provision which specifically excludes application of the provisions of the code. So far as the place of suing is concerned, Section 20 is relevant provision in the CPC which restricts the rights of parties in selecting the place of suing, confining it to the place where the defendant is carrying on business. However, under Section 134(2), the right of the parties is enlarged, kindly mark this, enlarged in such a way that instead of instituting the suit in a place where the defendant is residing, it can be instituted in a place where the person instituting the suit resides or sells its products, or where there are more than one plaintiff in a place where any of them actually and voluntarily reside or carry on business or personally work for gain. The said provision clearly empowers the person filing the suit to initiate the suit for infringement of his trademark right, either in a place where he is carrying on business or in one of the places where more than one person is suing in the said suit. In the said instant case, there are 3 plaintiffs. The first and third plaintiffs are having their place of business at Mumbai. The second plaintiff is doing business in Mumbai as well as Bangalore. The place of business of the first defendant is Australia, and that of business of the second defendant is Mumbai, and as well as in Bangalore. Under Section 134(2) of the Trademarks Act, the plaintiffs have ample choice to choose the place to sue the defendants either in Mumbai or at Bangalore. Therefore, they are justified in filing the present suit in the City Civil Court at Bangalore. The suit filed by the plaintiffs herein against the defendants is proper and maintainable. The contention of the petitioner first defendant to state that the suit is not properly filed is incorrect. Further, the petitioner has relied on the following rulings. These are, my lords, the judgments, including this Sanjay Dalia's case. Careful reading of the aforesaid judgments clearly discloses that the ratio enunciated in the said decisions have no bearing on the points for consideration in this revision, except the last judgment. That is in the case of, in the matter of Indian Performing Rights Society versus Sanjay Dalia of the Delhi High Court, which deals with a similar situation where the Delhi High Court has taken a view that in the matter where the infringement of the trademark is alleged, that in addition to the provision under Section 134 of the Trademarks Act, the plaintiff will also have a right to choose to file a suit taking recourse to the provision section 20 TPC. Be that as it may, the ratio laid down in the said decision does not run contrary to the finding of this court, inasmuch as opining that under section 134 of the Trademarks Act, the plaintiffs have the right to file the suit in its place of business. Accordingly, in the instant case, plaintiffs can invoke the territorial jurisdiction of the Bangalore courts and file the suit in the City Civil Court at Bangalore. Therefore, the trial court has rightly dismissed the application filed by the first defendant. And accordingly, at para 21, the order rejecting the application under Order 7, Rule 11 was confirmed. And this is because your lordships have marked at para 18 that the defendants were also carrying on business in Bangalore. And the plaintiff had the right, because he had business in Bangalore, go under 134(2). This judgment, by reading the head note, it appears the trial court has got slightly misled.
This line also, you read para 18.
Yes, my lordships. The answer, your lordship's answer is there on the para.
No, that this finding is also contrary to that 134. You read that. You read para 18.
Section 134 of the Trademarks Act empowers the plaintiffs to file a suit for infringement before the district court. Clause 2 includes a non-obstante provision which specifically excludes application of the provisions of the CPC.
That is wrong.
That's not correct. It does not exclude.
That is what that 134 includes.
As per section 20, where defendant is there you have to file a suit. Section 20 says, but section 134 excludes and empowers the plaintiff to file a suit where he resides.
That addition power.
No, my lord. If that is not excluded, then he has to come to the defendant's
Then
place.
say, that should be say, then section 20 itself is not applicable.
Yes,
That
sir.
is not the intention of the legislation.
Card of
Yes,
the
sir.
exception, Supreme Court clearly says that.
That will come to that where
yes,
we are
sir.
saying that.
So, that
Otherwise, simple thing is that they need not say only jurisdiction available for that plaintiff is under 134.
No, but what they have to do. If one of the branch office of the, in that case, fact is that one office is in Bombay, branch office is in Bangalore. So it's like jurisdiction is there. I'm also telling the same thing.
No, no, we are
Yes.
not on the, you reading that language which is used.
If it
134.
excludes saying that you did not go to the defendant's place. You can do institute a suit in your place, principal place of business.
No, that is 134 says.
Yes, my lord. No,
But
no, my lord.
power which is given
No,
under
that
20 is not taken over.
Not taken away.
The what it says, notwithstanding anything contained in section 3020, that's the language of 134. Notwithstanding anything
Yes, but
contained in
it
section 20 of
includes,
the
yes.
State Act.
Friend
It's
is
not
right.
absent clause, my lord.
Friend is right. It is non-obstante. But notwithstanding anything contained in the Code of Civil Procedure, or any other law for the time being imposed, include a district court. So it includes, it's an additional remedy. It does not take away the remedy under 20C, and that is the consistent view. Not Davidoff's case. But Davidoff's case, which your lordship saw Karnataka High Court, following INTAS, has categorically held it's an additional remedy.
Yes.
Notes 134 was never meant to deprive the plaintiff. It was a special remedy if you register. And in any
No,
case,
otherwise, it is nothing but discrimination. You are giving a defendant to sue anywhere he wants.
If section 20 is taken, where plaintiff has to file a suit, where defendant resides. Now, in view of that non-obstructive clause of 134, it says no.
That is what that, see, normally he has to file the suit where the defendant is there. 134 has given further power.
No, because of the non-obstructive clause, they excluded 20. Then they told yes.
No, restriction which is there.
It's 20.
The restriction under the 20, he can file it under 34. Otherwise, they.
No, but Supreme Court is clearly said now. Yes.
And in any case, your lordships have seen 134(2) is only in respect of A and B.
Yes, it is
Not
for-
C. My suit is also for passing off.
What is that regarding that? Passing off is also that. No, let him complete.
So, my lords, this question now is squarely answered by the judgments your lordships have seen in Ultra Home, Intas, and serial number 5, which are both division bench judgments of the Delhi High Court, and followed by our court, my lords, in Davidoff, serial number 6. This judgment at serial number 7, Unilever, also, my lords, the trial court has wrongly relied on. And please see one other judgment of this honorable court at serial number 8, which is Bhagwati Express's case. On first principles, once at page 160, the relevant portion is at 171. On cause of action, para 16.
170.
Page 171. The issue is at 171, whether the court at Bangalore had jurisdiction to entertain this appeal and whether any part of the cause of action is raised within the jurisdiction of Bangalore. Now, please see the answer at 16. So far as point 1 is concerned, it is admitted by both parties that the consignment were entrusted to the defendant at Delhi with a clear understanding that the consignment shall safely be delivered to the second plaintiff at Bangalore. In the lorry receipt at P3, it is printed that the suit shall be filed only if any dispute shall be within the jurisdiction of Delhi. Long back, the Honorable Apex Court has held in many cases that by agreement, parties cannot confer jurisdiction of the court. Therefore, the contention of the appellant that the plaintiffs were required to file the suit within the jurisdiction of the Delhi court has to be negated. Then we have to consider whether any portion of the cause of action has arisen within the jurisdiction of the Bangalore city. So far as this point is concerned, as per the terms and conditions of the lorry receipt, the consignment was to be delivered to the second plaintiff at Bangalore. Admittedly, the consignment has been delivered to the second plaintiff at Bangalore. When the consignment has been delivered to the second plaintiff at Bangalore, it goes without saying that the cause of action has arisen within the territorial jurisdiction of Bangalore. In these circumstances, the first point has to be answered against the appellant. This is, of course, on first principles. It does not deal with 134 of the Act. And finally, my lords, please permit me to show two other judgments of the Delhi High Court again. Page 39 is the judgment, my lords, in Burger King. It seems most of the judgments on trademark law are emanating from Delhi High Court, my lords. Serial number 2, my lords, page 39. Please come to para 16. Para 16 again refers, my lords, to Sanjay Dalia and Ultra. And 134, I'll skip that. Take your lordship to para 17. A perusal of the above paragraphs clearly shows that insofar as the explanation to section 20 is concerned, the same relates to section 20A. The Supreme Court categorically observes that section 20 enables the plaintiff to file a suit where the cause of action arises under section 20C. The remainder of the judgment in IPRS versus Sanjay Dalia primarily deals with and interprets the manner in which section 134 of the Trademarks Act and section 62 of the Copyright Act can be invoked, but does not dilute the principle of section 20C of the CPC in any manner whatsoever. Even the division bench judgment of this court in Ultra Home, while interpreting 134 of the Act and 62 of the Copyright Act, has laid down various tests. That judgment your lordships have already seen, lords. Ultratech I have read. Please now come to para 18, which answers the question before your lordships. Thus, the provisions of section 134 of the Trademarks Act and section 62 of the Copyright Act are in addition to and not in exclusion of section 20 of the CPC. If the plaintiff can make out a cause of action within the territorial jurisdiction of this court under section 20, no reference needs to be made section 134. Finally, notes at page 53. The same view, my lords, is reiterated. Para 8 at page 56. Be remarked. Just there. But para 8 at page 56, the question of territorial jurisdiction in matters relating to infringement of trademarks is now well settled. Judgments relied upon by the defendants in Dahlia and Ultra Homes deal with the situation where the jurisdiction is clearly determinable on the basis of section 134(2) of the Trademarks Act and also under 62 of the Copyright Act. Therein it has been observed that the aforesaid provisions of the Trademarks and the Copyrights Act are in addition to section 20 of the CPC. Thus, the plaintiff is entitled to file the suit for infringement of trademark where the cause of action arose under section 20C of the CPC. Now, just see the statement of objects and reasons for 134. And I'll conclude with this submission. Notes. Objects and reasons in the Bare Act itself under 134 is extracted. This clause stipulates
There in the beginning.
Lords, it's under 134 itself. May I give your lordship
34 of the object is not there. Yes.
May I please furnish a copy? Objects, Lords?
Yes.
Clause 134. This clause stipulates the forum for institution of infringement proceedings to be before the district court. It is proposed that the term district court having jurisdiction would include a district within the local limits of whose jurisdiction the person or one of the persons instituting the suit or other proceeding actually or voluntarily resides or carries on business or personally works for gain. This amendment would bring the trademarks law in line with the provisions contained in the Copyright Act, as very often a trademark is also registered as an artistic work under the Copyright Act. So wherever there is registration, be it of a trademark or of a copyright, that special remedy is there even under the Copyright Act. Note section 62(2) provides that if you have registered your copyright, you may sue where the plaintiff resides. But that does not, my lords, tantamount to an exclusion of section 20C. With great respect, the trial court has misdirected itself and held that 20C is excluded. This is a patent error, my lords. The cause of action paragraph clearly demonstrates the cause of action in Bangalore, which is sufficient to suit to have been entered. That's my submission.
Yet, to start with, the serious consideration, that the object and reason to be kind of first thing. The foundation for
Yes.
let me kindly read. Take your lordship to the object and reason. Section 134. This clause stipulates the forum or institution of the infringement proceeding, etc. to be the district court. It is proposed that the term district court having jurisdiction would include district court within the local limits of the whose jurisdiction the person or one of the person, very important mark, madam. A person who is instituting a person or one of the person but instituting a suit or other proceeding actually or voluntarily resides. This is what precisely trial court has said.
The thing is,
Yes.
the person who is carrying that business,
Yes, ma'am.
the 20, he cannot institute the suit where his office is there.
No,
To
fine.
give one more benefit, 134.
20 says where defendant resides.
See, if 134 is not there,
They
he
could
has
not
to,
have been filed.
no, he has to file a suit where the defendant.
Defendant's place.
See, give one more advantage to that plaintiff. 134 has introduced.
Yes, what is it? It must be the local jurisdiction of the district court.
That's what that. See, which is not given under 20, we are giving under 1.
Yes. What that either the one of the plaintiff
No, there is
suing.
no, if you want to file in a suit under 134, he has to file where his office is there.
Not a
Under
problem.
one,
No, but here 134 he can file, not in the place. It's the exception carved out. He says 134 he can file in the suit where he resides, not the dependent, or one of the plaintiff resides. Here neither the plaintiff resides within jurisdiction, one of the plaintiffs residing within the jurisdiction.
no, that's what he's saying, that I am not exercising the jurisdiction under 134.
Wrong,
It is under
I
20.
take-
Now that we come to that, whether.
Now I first take
Yes. Now,
plaintiff protected under section 134.
134, it includes passing off or only infringement?
Yes, well, I state under which provision he submitted the claim at his paper book at page 53.
Yes.
For convenience argument order, he filed this petition under section 34, 134.
Yes.
Page 53, plaint filed under section 26 and order 7, rule 1 of the CPC 1908, that with section 27, 28, 29, 134 and 135 of the Trademark Act 1999. Then he cannot say, no, I have not exercised 134, I exercised 20. No. This plaint is under section 134, number 1. Number 2, my lord. Again, I will take a lordship the previous page of that compilation, page 52. Page 52. There are two plaintiffs, my lord. Their address will be kindly seen. Yes. Varun Chopra.
No, there is no dispute that they are not residing here.
Not residing, no business thing. Now, this is clarified. Well, neither plaintiff residing, nor dependent residing within the territory of bank. Now, I will take a lordship for that cause of action. Page 72, para 52.
Yes.
Para 72. Page 72, para 52. According to them, when the cause of action arose? 72.
Yes.
Para 52.
Yes.
The cause of action arose in August 2022.
Yes.
When the plaintiff first became aware that defendants use and application for registration for a trademark, SV Natraj and Sri Natrajji, when I applied for a trademark in Delhi, he came to know that cause of action arose to him. I applied in Delhi. According to him, cause of action arose when I applied. He doesn't say that after sale or any sale. This cause of action parameter kindly seen. So according to him, I applied in Delhi for these two brands. Those applications are pending. Then cause of action arose. That can be seen kindly seen. Use and application for registration of the trademark SV Natraj and Sri Natrajji. The cause of action as further arisen each every day before and after August 22. Whenever defendants have made the use of opposite trademark, this is within the case. So there is no reference that the sale is a cause of action in Bangalore, but application for trademark is a cause of action for them. Now, second point I clarified, my lord. Now I will take your lordship to the all the judgments cited by the learned senior counsel is regarding one of the branch officers are in that jurisdiction of the district court. All the judgment. The para 18 of that judgment of our own high court. All the judgment where one of the branch office or a subordinate office or a head office is within the local limits of that district court. Now I will read that para 18. Para 18 is answer for the entire argument can also learn the counsel for the appellate. I demonstrated that none are residing within the jurisdiction of Bangalore. That's the admitted fact. At the cost of repetition, I will repeat that para 18 because it's having answer. Page 157 of their compilation.
Yes.
Yes.
57.
Yes, para 18. Section 134 of the Trademarks Act empower the plaintiffs to file a suit for infringement, etc. before the district court. Clause 2 of the said section includes a non-abstention clause which specifically excludes the application of the provisions of Code of Civil Procedure. This may be highlighted, Madam. Excludes the provision of the Civil Procedure Code. So far as the place of suing is concerned, Section 20 is relevant, confining it to the place where the defendant is carrying on its business. Section 20 says only defendant's place plaintiff can file a suit. Then, Madam. However, under Section 134 subclass 2, the right of the parties is enlarged in such a way that instead of instituting a suit in a place where defendant is residing, it can be instituted in the place.
What is that meaning then? See, it is enlarging suit in place where the defendant can reside. There also it can be
Yes,
filed.
but the first 20 is excluded.
Now, if it is excluded,
then
what is the reason for the court to say here that including that place you can?
Yes, but that section by virtue of Section 134.
No,
134 empowers.
Court in the beginning said
CPC excluded.
CPC excluded.
Yes.
In the next, immediately after the 2 lines, it said that
20 is also excluded.
Instead of instituting the suit in the place where defendant residing.
As per Section 20. Yes, Parent. That is excluded now. He did not go to the defendant's place.
ಅಲ್ಲ ಹಂಗಂದ್ಬಿಟ್ಟು ಮತ್ತೆ ಕೆಳಗೆ ಏನ್ ಹೇಳಿದ್ದಾರೆ ಸಾಹೇಬ್ರು ಅಂದ್ರೆ enlarge.
Yes, Parent. Enlarged by virtue of 134. Enlarged by virtue of the non-obstante clause of 20 has created.
Yes.
Then a special right has been created to the plaintiff, saying that you did not go to the defendant's place.
Yes.
You file where you are residing or carry on the business or your subordinate office located. That's what I am telling you.
It says it can be instituted in addition to that.
Yes, Madam.
Where respondent
You did not go to the defendant's place, you can file in your place or in your subordinate office.
However, under 160, right of the parties to enlarge in such a way that instead of instituting the suit in the place where the defendant residing, that instead of
yes, you did not go there. In your place only you will file.
ಅದೇ
ನಿಮ್ಮ ಪ್ಲೇಸ್ ಅದನ್ನೇ ಹೇಳ್ತಾರೆ ನಿಮ್ಮ ಪ್ಲೇಸ್ ಅಲ್ಲ ಇದು ಬೆಂಗಳೂರು ನಾಟ್ ಯುವರ್ ಪ್ಲೇಸ್ ಯುವರ್ ಪ್ಲೇಸ್ ಇಸ್ Saranpur. That's what I'm telling you. If he is having a branch office here, then he is having a right.
Yes, yes, yes.
That's in this facts of this case is, my lord. He is having one office at 2 plaintiffs are residing in Mumbai, one is residing in Bangalore. Then he told you he is in jurisdiction. I am also there. And another case, what he told, some materials or goods shall be dispatched to the branch office of the defendant in Bangalore. He is having a branch office in Bangalore. They have jurisdiction in Bangalore. What I am telling, here he is not having a branch office or a head office. Either the plaintiff or the defendant. Then he has to go to Sara. This is precisely what told by the Honorable Supreme Court in 2015 judgment. I will take your lordship to that. I will complete this paragraph. Enlarged in such a way that instead of instituting a suit in a place where the defendant is residing, it can be instituted in a place where the person instituting the suit resides. Very important, my lord.
It can be instituted ಬರಲ್ಲ ಅವಾಗ.
Yes, my lord.
He can only instituted ಅಂತ ಬರಬೇಕಾಗುತ್ತೆ.
ಅಲ್ಲ,
Yes.
he has to ಅಲ್ಲ ಇಲ್ದ್ರ ಬರೋದೇ ಇಲ್ಲ. Section 20 ಮೇಲೆ ಹೋಗ್ಬಿಟ್ರೆ ಖಾಲಿ 20 ಅಂದ್ಬಿಟ್ರೆ ಅವರು ಎಷ್ಟು go to defendant's place. ಈ 134 proviso ಯೂಸ್ ಮಾಡಿದಾಗ he can file in his place.
Yes.
Otherwise, he has to go. If he says 20C, that I will take in lordship the plaintiff elements. He says this plaintiff is filed under Section 20C, then he has to go to his place. Otherwise, I will take in lordship to that.
First issue, I am deciding whether 20 is applicable or not.
Yes, madam.
ಆಮೇಲೆ ಅವರು cause of action ಹೇಳಿದಾರೋ ಇಲ್ಲ, that has not been decided. That is what.
Plaintiff is under 134. That is not in dispute now.
Yes.
Now, this judgment para 18 says that is after the insertion of the proviso.
Yes.
Then he can file a suit where he resides,
yes,
voluntarily resides, carry on the business, or a subordinate office carry on the business.
Yes.
With this, I will read out this paragraph.
Yes, yes.
Place where the defendant is residing, it can be instituted in a place where the person instituting the suit resides or sells its product, or where there are more than one plaintiff in the place where any of them actually and voluntarily reside, are more than one plaintiff reside, or carry on the business or personally work for gain. It's very important, a rider. The said provision clearly empowers the person filing a suit to initiate the suit for infringement of trademark right, either in the place where he is carrying on the business or in one of the places where more than one person is issuing the said suit. This is very important. This is the only places where he can file a suit. In the instant case, there are three plaintiffs. First and third plaintiffs are having their place at Mumbai. And the second plaintiff is doing his business in Mumbai as well as in Bangalore. So, in that context, it was held to is maintained. So, the place of business of first dependent is in Australia. That is not the criteria. And that the business of the second dependent is in Mumbai and as well as in Bangalore. So, here, plaintiff is also residing in Bangalore. Dependent is also residing in Bangalore. In this background, we will take a lot of the Supreme Court judgment.
Yes, because you can take 100 cases of the Delhi High Court where both of them is residing in some other places. Only the transaction, that also in the third party transaction has been taken in Delhi. Delhi held that it is maintainable under 20. Now, this is also High Court. You show that Supreme Court.
Now, Supreme Court said that has not deprecated, my lord. I first take a lordship to that aspect, my lord. Yes. Why all these suits are held maintainable? The Supreme Court has made an observation, a further observation. I will take a lordship to my comparison.
Because as on even 2023 judgment of Delhi High Courts has held that it is maintainable under Section 20.
What has happened, my lord?
Whether Supreme Court judgment which you are relying as considered by the Delhi High Courts, or what is that judgment says? Now,
yes, my compilation, page 37, kindly see. Why those all suits were filed in Mumbai, Delhi at that point of time, now in Bangalore, precisely answered by Honorable Supreme Court. The concept of jurisdiction is expanded by the advocates. That is what Supreme Court says. My compilation, para 57, para 50 and page 37. It's an Indian performing society. Yes,
serial number 1. Better it is.
Yes,
if it is there, I can refer one this thing.
Yes, page 50, my lord. There.
Yes, yes. First judgment.
Yes.
No, you can read in your, because you might have been marked it.
Yes,
Mr. Bhagwan. Yes, yes.
Both are same page. Para 50, my lord.
Page 37.
37, para 50.
Yes.
But why those suits were instituted in Delhi?
Yes.
And now in Bangalore, precisely answered by Honorable Supreme Court, my lord.
Yes.
It was also submitted that bulk of the litigation of such nature is filed in Delhi, and lawyers available at Delhi are having expertise in the matter. As such, it would be convenient to the parties contest the suit at Delhi.
Yes.
Such aspects are irrelevant for deciding a territorial jurisdiction. It is not the convenience of the lawyers or their expertise which makes out the territorial jurisdiction. The submission is unnecessarily rejected because the suits were filed in Delhi because of advocate's convenience. That has been deprecated.
In Bangalore, it's also given one feather to you also as an advocate.
No.
That's
yes, that is the what why the lordship asked why all these are filed in Delhi.
Yes.
Trademark experts were in Delhi, now in Bangalore.
Yes.
So for the convenience of the advocate, suits are filed here. What I am telling you.
Yes.
Now I will take a lordship. Para 16, page 16, para 14 of that very same judgment.
Para?
Para 14.
1-4.
Yes, ma'am.
Yes.
Considering the very language of Section 62 of the Copyright Act and Section 134 of the Trademark Act, an additional forum has been provided. Additional forum, very important.
Yes.
By including a district court within whose limits the plaintiff actually and voluntarily resides or carries on business or personally works for the gain. Very important, this aspect. The object of the provisions was to enable the plaintiff to institute a suit at a place where he and they resided or carried on business, not to enable them to drag the dependent further away from such place, also being done in this instant case. Our case also very same fact, my lord. To drag the dependent who is in Saharanpur to Bangalore. Next, my lord. In our opinion, express notwithstanding anything contained in the Code of Civil Procedure does not alphabetically applicability of section 20 of the Code of Civil Procedure, and it's clear that additional remedy has been provided to the plaintiff so as to file a suit where he is residing or carrying on the business, etc. As the case may be, section 20 of the Civil Procedure could enable the plaintiff to file a suit where dependents reside and or where the cause of action arose. Section 20A and 20B usually provides a venue where the dependent or any of them reside, carries on business or personally works for a case. Section 20C of the Code of Civil Procedure enables the plaintiff to institute a suit. It's very important for here in the next 6 lines. Institute a suit where the cause of action wholly or part arises. The explanation 20 of CPC has been added to the effect that corporation shall be deemed to carry on business in its sole and principal office in India or in respect to any cause of action arising at a place where it has a subordinate office at such place. Thus, corporation can be sued at a place having its sole and principal office and where the cause of action wholly or partly arises at a place where it has also a subordinate office at such place. So, cause of action plus subordinate office.
I think this judgment is not in your favor.
It's very.
See, they say, see, in addition to that, again, see.
You don't see, you must have a place.
No, they said, even doesn't would the applicability of the provisions of section 20 of the CPC.
Yes, madam. Last what is yes, but to take benefit of 20C, cause of action plus your residence. That is important, madam, what I am telling. Yes, principle is main object is 20 is correct. To apply the cause of action, you must have a branch office, subordinate office in that place.
Then what is the use in saying that 20 is also applicable?
Well,
then it is contrary to that section 20.
No, but 20 is not taken away entirely, but a special code has been created.
Your argument is accepted. 20 is watered down.
No, matter, sir. 20 is clarified by the non-obstacle clause. First, non-obstacle clause can be least better. It doesn't say anything regarding section 20. Generally, what happens, madam, if cause of action arose in the Munsif's code, I have to file a suit in Munsif code. But because of the non-obstacle clause, if anything happens, you can file a suit in district court. That is the beauty of that non-obstacle clause, madam. Just I read it that non-obstacle clause. It's not section 20. Only that jurisdiction of its ordinary city civil court has been vested with the district court.
Yes.
Not the section 20. I will take a lordship to now again to section 20, madam.
Yes.
It does not say anything regarding section 20. Sorry, 130. Sorry, 134.
Yes.
It does not say anything regarding 20. Clause 2, minus 134 sub clause 2.
Yes.
For the purpose of clauses A and B of subsection 1, a district court having jurisdiction shall, notwithstanding anything contained in the Code of Civil Procedure for 1908 or any other law for any time being in force, include a district court having local limits. Here, rather than going to official court under section 20, district court has given power to file a suit of infringement. That is the only intent of the.
Then where is that exclusion of section 20 then?
Nowhere.
Where that CPC is not applicable?
No. What I am saying now, 20C can do, did not go to the official court, you go to the district court, but with that, you have to show that you are having a head office or a branch office, then you can file a suit. That is the entire thing clarified in para 18 of this Honorable Court's judgment, para 14 of the Honorable Supreme Court's judgment. That what is precisely held by the trial court. You are not having a subordinate court here. Otherwise, you have to find a suit where defendant is there. Yes, you are given a permission. You did not go to municipal court or a municipal court. You can find the district court wherever.
20C has been added. After that, adding 20C, it is not that.
C was there. A proviso was added. I will take a question with
No,
that.
that 20C is, I think, added later.
No, my lord. C was there. Proviso was added to 20C.
Otherwise, the argument that it is only a place of defendant would not arise as because
Yes, but
cause of action.
yes, explanation to section 20 BBC, my lord. The C was in the beginning only, my lord.
Somewhere I read 20C as
No, my lord. Explanation, my lord.
beginning it is there.
No, my lord, no, I meant the beginning only it is there, my lord. Explanation to be taken, my lord. Explanation was added in 1977.
No, that means to say that it is independent to that A and B.
Yes, my lord.
Now that why that arguing that only place of defendant suit has to be.
Explanation, my lord. Explanation, section 20.
Yes.
The explanation. A corporation shall be deemed to carry on a business at its sole or principal office in India or in respect of any cause of action arising at a place where it has to a subordinate office at such place. This explanation, because of this has been considered thereby. We have to read this explanation with 134. If this explanation was not there, he could not have been filed. For that, he has to tell his head office or a subordinate office plus cause of action. So it is explanation to C, added in 1977. Otherwise, what it says, beginning words of section 20 will be kindly seen, madam. Other suits to be instituted where defendants reside or cause of action arises. Subject to the limitation above said, every suit shall be instituted in a court with the local limits of jurisdiction. This local limits, what was there, my lord? By way of the explanation, subsection 2 to section 134, local limits have been given to the district court. So that's the only non-obstante clause refers to. Then this explanation defines section C. Therefore, jurisdiction based on the cause of action plus place of residence or carrying of business is a criteria to determine the jurisdiction.
No, that has been given under 134.
134 doesn't say, my lord. 134 says only district court. That I am telling, my lord.
Yes.
134 doesn't give right. 20C explanation gives right.
Yes.
There only it says district court, what is defined under the CPC or any other law in typing in force shall be deemed to be a district court, not the local official court. How is it explained, madam? Here explanation what it says, it also a subordinate respondent. India is the cause of action arises at a place where it has to carry on with them. Here normally it has to go to an official court, civil junior division or senior division. But by virtue of that non-obstante clause.
No, here, see, person who institute the suits, where one or more persons of them voluntarily residing carries. That's
Yes, madam.
that is there.
Yes, madam. But one cause of action is not there. That is a which is the forum. By way of a non-obstante clause, forum is decided. You did not go to the official court. For example, if in Tumkur, in Kupi something happened, he did not go to Kupi court. He can go to Tumkur district. That only the yes.
If you say non-obstacles class is not for the 20, then it is still worse.
Yes, no, that no, it is. Because of this explanation, by virtue of this explanation, to 20 subclause C, a forum is created. With that. But what is the rider? You must reside there, or any one of you must reside there, plus cause of action.
For 134.
Yes, ma'am.
For 20, why can't you
20
file
a forum has been created, cumulative 134 and a corporation that defined.
According to you, first part of 134 class 2 is district judge is the
designated
judge or jurisdiction.
Whatever
second part is the plaintiff where he is residing can also file in a suit.
Yes.
But it doesn't say that 20 is excluded.
Yes,
then he can filing an 20.
Yes, what is suit filed at 164?
By mentioning
Suit
that
filed
the wrong
134.
provision, his right will not taken over.
What if the exception is created for section 20 by this explanation? So he can file, but provided it's a benefit of the plaintiff, which was done. And Supreme Court in crystal clear term held, you cannot by taking the advantage of section 20 subclause the 3
No, that is what you are arguing also. That is also not correct. Notwithstanding anything contained in the civil procedure code, entire civil procedure code, you can't say that only for jurisdiction of the district court.
No,
even if
definition
you
of
take
district court.
that entire
Even if for the sake of argument, if I say that 20 is also included, then also by not purposive interpretation, then also the place of precedent carrying on with this purpose. My reading says only district court has been wherever jurisdiction was there. It's an exclusion to the exception to section 20 it is. This non-obstante clause is an exception to 20. 20 says 20 beginning of section 20 maybe once again may be read. It will be read section 20 once again. Beginning word. The other suits to be instituted where the dependent reside or a cause of action arises. Subject to limitation aforesaid, every suit shall be instituted in the court within local limits of whose jurisdiction.
Yes.
For that purpose, my lord, yesterday, no need. You did not go there. You can go to district court. Local limits, you did not go to municipal court, you did not go to the civil judge, senior division. Directly, you can approach the district court of that district.
No, why that it's argued that under section 20, suit can be instituted only where the defendant residing. That's not the
He says,
Not cause of action. Subject every suit shall, not that they may, shall be instituted in the court of local jurisdiction where dependent reside or cause of action arose. But by creating an exception, plaintiff has given an enlarged scope, but one rider. You must reside within the jurisdiction of the district. Even, for example, he did not reside in the Tumkur. If he resides in Kuppiyar, he can file a suit in Tumkur district.
You are saying that within that district he has to be residing.
Yes, rather than having two-tier litigation, at the first, then after that, high court. That's the only object of the act. Therefore, cumulated into 134, section 20, his plain government under which he has applied, cause of action in paragraph 22, Supreme Court judgment, and this honorable court in that paragraph 18, the judgment entered by the trial court proper. All of the judgments cited by the senior counsel, where they are residing in the jurisdiction, they are tied in section 20. There it has been disfavored, not favored in favor of the dependent. No judgments are produced to say that he is not within the jurisdiction of the district court, can file a suit. On the other hand, that first judgment of mine clearly says
yes.
The jurisdiction starts from place of suing from section 15, my lord. All where says where subject matter situate, where immoved property situate, where injury happened. This is section 20 itself is an exception for rule 15 to 19. But to extract this for under the Trademark Act, there's two criteria are very much necessary. Place of working or place of business plus cause of action.
Yes, Mr.
Just one paragraph I read and conclude my argument. The judgment in the Indian performing, last paragraph 51 and 52, madam. Page 37 only.
Where compilation.
Both compilation, page 37. Para 51.
Yeah.
It is also submitted that the suit may be ordered to be transferred to Delhi. The prayer was made.
Yes.
There they have refused to transfer. They told rejection is correct.
Yes.
We cannot transfer in the suit these proceedings. In case parties so desire, they are free to file an appropriate application, but the suit required to be presented in the court of competent jurisdiction. Only thereafter, question of transfer would be germane. Paragraph 52. In our opinion, provisions of section 62 of the Copyright Act and section 134 of the Trademark Act have to be interpreted in a purposive manner. No doubt about is that the suit can be filed by the plaintiff at a place where he is residing or carrying on the business or personally works for gain. He need not travel to file a suit to a place where the defendant is residing or cause of action wholly or in part arises. However, if the plaintiff is residing or carrying on the business, etc., at a place where the cause of action wholly or in part has also arisen, he has to file a suit at a place as discussed above. Means cause of action plus office, subordinate or head office. Thus, the aforesaid reasons mentioned us in the judgment, we are not inclined to interfere with the order passed by the High Court. The appeals are hereby dismissed. The entire answer is covered by section 20, 134. What is the necessity to invoke 120C? Everything is there.
Now that section 134 is applicable for passing off.
Yes, my lord.
Where is that?
Whole section they are 134 on the suit file.
No, 134. Not mentioning that wrong provision will not take away that is right which is there.
No,
now that
134
no, you have addressed that argument. It's important point. I want to ask him to that clarification.
Yes.
Now that he has addressed the argument, 134 is not applicable for passing off.
Then his suit has to be dismissed for provision.
No, in passing off, again he has to rely on section 20.
Yes, but what I'm telling you, section 20 he can do.
No,
Section
see,
134 also.
Section 134 is exclusively for where he has infringement of, trademark where he has registered. If it is a passing off, then 20. Because there under section
passing off also is a cause of action.
No.
Passing off also is a cause of action.
If you read that, if you accept your arguments, 134 is not on the cause of action. What 134 says, see, any person wants to file in a suit, he should be residing within the jurisdiction of the district. That is what that you have argued also.
Yes,
that is what that.
Now I take a question.
No, 134 says it is not related to the cause of action.
But section 134 is the law alone section which empowers the plaintiff to file a suit under the Trademark Act. No other provision. No other provision.
No. See, 134 non-obstacle class only in respect of that
district court
infringement, not passing off.
No, my lord. That's the wrong.
No, you show me the judgment. Because 134, what the way he has reading is also correct. That, what he said, see, 134, it is not in related to that any this thing for this cause of action. It says that 134 for infringement, person who wants to file residing within the jurisdiction of the district.
134(2).
134(2), that is section. Yes. It is not that in addition to that, you have to be there. It said notwithstanding anything contained that CPC. If you want to file in a suit, you should be residing within the district.
Under the CPC, a plaintiff could never file a suit where the plaintiff resides. Plaintiff would necessarily have to go under A and B of section 20
Yes.
where the defendant resides, or in C where the cause of action arises. This special right under 134(2) was created in respect of A and B, that is infringement, where the plaintiff resides within the district. No dispute.
See, what they are saying that even though there is a bar under the 20 regarding that where he has to reside, he has to file. In addition to that,
134.
That is what that 100 of judgment which has been released.
But all the judgment says,
Even judgment 2015 you are relying. They said Supreme Court, in addition to that, they said.
correct, madam. Section 134 is a substantive. It's like a place of suing.
No, substantial class is not against that plaintiff. It is in favor of that plaintiff. What
Yes,
say?
madam, I'm telling. What it says, you did not come to bank, file a suit in your place only.
No. Why that substantial class has been incorporated? Without that, if that legislation has used in a language saying that you have to file in a suit only place where you are residing, it is contrary to that section
Yes, no,
20.
no.
Therefore, not
20 says you have to file, plaintiff has to file a suit in a place where defendant resides. But by virtue of this, they say you can file in your place only. That's what I'm telling. You file in Delhi, or Saharanpur, you file. You are not.
See, 20 is not provided him to file a suit where he is residing. Now, 134 given that power.
Explanation clearly says that again I will read better.
Yes, I read that. Yes.
Yes, plaintiff is given power that is because of this explanation. Cumulative reading of section 2 and explanation
Yes.
that has extended the scope of plaintiff's jurisdiction.
Yes.
The 20C may be kindly said, 20C explanation.
Yes.
That only a corporation shall be deemed to carry on provision fiction has been created here. Carry on the business at its sole and principal office in India or in respect of any cause of action arising at any place where it has also subordinate office. Even the Bangalore cause of action happened, deemed to be happened in his place.
Where is that?
The corporation is the plaintiff.
No. Why? Only the plaintiff should be a corporation. Dependent cannot be a corporation.
This is the power given to the plaintiff. Who institutes my lord? Dependent doesn't institute suit.
Power not giving. What says you want to institute the suit, you see that defendant has to be there in these are the places.
No, my lord. And it's the sole principal place of business. It can deemed to be arising cause of action. If Bangalore cause of action
if you say all that earlier provision is for the defendant, now that explanation is also should be read as a defendant. It cannot be said.
It says plaintiff, you have to file a suit in the place of defendant. I'm not telling it's applicable to plaintiff. It says to the plaintiff, you have to file a suit in the place of defendant.
Defendant, yes, he should also have in a corporated office.
Yes, madam. Now it says it's a company.
Because his office is there, but he has a rented house in that some other place. Don't sue there. You sue where this office is.
Yes, madam. And then cause of action arose in Bangalore also, deemed to be cause of action arose where he is retired. That's what I'm telling, my lord. Yes, what I'm telling, he did not come to Bangalore. By virtue of section 20 explanation and section 134, he can sit in Delhi, sit in Saharanpur, where he is having, and file a suit saying that Bangalore infringement has happened, passing up has happened. I am residing here by virtue of 120, let me say 20C. I am having jurisdiction to this court. Yes. That's what held by this honorable court and Supreme Court. He did not come. It's a benefit to the plaintiff. He did not go to the defendant's place. He can file a suit in his place. Deemed a cause of action arose within the jurisdiction of that court, where he resides. It's the object of explanation and non-obstructive clause 134. Yes.
What is your reply regarding that passing off?
Even section 20C explanation says that passing off.
No, 134 is applicable to that passing off also or not?
No, what I'm telling you, he filed the suit under section 134.
Yes.
According to me,
you forget about what he has filed.
134 wrongly or 134. Then
you forget about this case.
Yes, ma'am.
As a counsel, you assist me.
Yes.
134 is applicable for the passing off or not?
By virtue of section 134 20C explanation, he can file even the passing off in his place.
You read 134.
Yes, ma'am. Because that's here, ma'am.
You read and
Yes,
explain me. That's what I'm asking.
For the purpose of explanation 2, ma'am. For the purpose of clause A and B,
what is
section 1. Then also, my lord, his suit shall fail. District court having jurisdiction, shall notwithstanding anything contained in the
there are A, B, C.
Yes, madam.
A, B, C.
B, my lord.
Class 2 says only A and B. Therefore,
my
I'm
lord.
asking C.
My
Whether
lord.
subclass 2 is applicable to that C.
Which
If
madam?
it is subclass 2 of 134 is applicable to that C or only A and B.
Registered trademark.
Which
Then
is
gives
no, they are
the
not
trademark.
No, his leading is even for passing off also.
No, my lord. When registered trademark doesn't come.
All that has to be decided in the
No,
trial.
This is a specific case is
No,
there.
Venkatesh, you forget about that your opponent. I am putting a question regarding passing off. If person wants to file a suit for passing off, 134 is applicable or not?
Applicable, my lord. If it's a registered trademark, he is claiming for a pass off, then also he has to go to his claim.
Yes.
Clause A for infringement of a registered trademark
Yes.
and relating to any right, registered trademark. He is claiming a right under the registered trademark, not
Yes.
the unregistered trademark.
Yes.
Therefore, he is again benefited by the proviso and proviso explanation to section 20.
Yes.
If he is an unregistered trademark, he is not having a registered trademark, then the exclusive clause will come, then he has to approach the ordinary civil court. Then that jurisdiction doesn't come. If he say, I am passing off mine, then he can file a suit before the district court. Then also I will take that A be applicable to district court. He cannot file a suit in the district court. Then he has to go to the trial court. He filed before the district court. Then that's how there is no jurisdiction to district court to decide regarding the passing off. In both way, he is having no jurisdiction. Then if he says I am give up a claim of passing off, then again he has to go to Delhi, Saharanpur. If he says, okay, this court is having no jurisdiction.
Suppose if that claim is for both infringement and passing off,
yes.
Where he has to go?
He has to go to his place.
No. Jurisdiction, whether district court or civil court.
No, main relief, I think. If it's a main relief, alone relief.
You have argued. I consider. I putting that question. You have to
Yes,
answer.
If
You have from the beginning of your argument is he has to go his place.
Yes.
Will not take out that.
Yes.
That's why I'm
For example, if it is relief, declaration, injunction, and consequential relief. If it's a consequential relief for passing off, then he has to go to district court of his
No,
jurisdiction.
if that person wants to file a suit for injunction only for passing off, he has to go to the civil.
Local civil.
Is it? Is there any?
That I have to check.
See that?
Yes, I will assist this honorable.
Yes, but we'll see that.
Yes.
What's the answer to the question of the honorable court
Yes.
regarding passing off is in 134(1).
Yes. 134. Yes.
No suit for the infringement relating to any right in the registered trademark, or C for passing off arising out of the use by the defendant of any trademark which is identical or deceptively similar to the trademarks. Plaintiff's trademark, whether registered or unregistered,
Yes.
even if it is registered, I can sue for passing off, shall be instituted in any court inferior to a district court having jurisdiction. So, my lords, whether it is for infringement or
Shall
passing.
be instituted in any court inferior to the district court.
So whether it is
inferior court, yes.
Yes.
Therefore, now whether it is a suit for infringement or passing off both, in light of 134 of the Trademarks Act 99, I have to sue any district court. The additional remedy your lordships have seen in 2, which applies only to A and B,
Yes.
is where the plaintiff resides. And that has been interpreted in para 14 of the judgment in 2015 Supreme Court to mean that it is an additional remedy. So I have an additional remedy. If I wanted, my lords, to sue for infringement, I could have also sued in Saharanpur. But because I am suing for...
See, if you are filing a suit only for passing off, then you have to sue only where that
defendant
because
resides.
34(2) is now 134.
Yes, my lord, that is why I have sued here, because I have sued for both passing off and infringement. Now for passing off, I have to fall back on section 20, subsection C.
134(2) benefit will not be
Will
there.
not be there. And that is the reason I have sued in Bangalore. If I wanted to sue only for infringement, I could have sued in Saharanpur because I am a registered owner of a mark. But my suit is both for passing off and infringement, and the parameters are different. And therefore, to get a suit filed for both infringement and passing off, I cannot avail the remedy under 134(2). I have no choice.
In the passing off, you don't have any registration.
No, for not passing off is a common law remedy.
Yes.
Section 27 of the Trademarks Act deals with it. 27(2). Yes. Nothing in this act shall be deemed to affect the rights of action against any person for passing off goods or services as the goods of another person or as services provided by another person or the remedies in respect thereof.
Both of them have no registration, but they are using that trademark.
Yes, but no, not for passing off. Registration. Is there any registration? I have a two-pronged attack in the plaint. One is I say my mark Natraj is identical and therefore you are infringing. I can additionally in common law say you are passing off your goods as mine. How is that? By having the packaging, the logo, the pricing. That may not come in infringement, but passing off. You are pretending to pass off your product as mine. And that is an additional common law remedy. That may not, I may have no case for infringement in a given case. But somebody may copy my style or my color.
That is a passing off.
That is passing. That's a broader remedy. I want to invoke both remedies. Therefore, I have to revert to section 20C. My learned friend's argument that the explanation to 20C applies to the plaintiff with great respect is misconceived. The explanation, my lords, is to section 20, which only refers to the defendant.
Yes.
It has no applicability to a plaintiff. The entirety of section 20 refers to the defendant. And the explanation was added, as your lordships rightly observed, where a defendant is a corporation, it is deemed to carry on business at its principal place. Therefore, a party can sue the defendant where its registered office is situated. That's all. And my friend, my lords, made much of the fact that my suit is under 134. Naturally, my lords, it is under 134(1).
There is an infringement also.
Infringement also and passing off also both.
Both is there under 134.
134(1). And therefore, my lords, to have the case presented and filed before the district court, I have to say 134. So it's not even that I have mentioned it accidentally. I have consciously mentioned. But I have not said 134(2). Yes. I have only said 134 read with the CPC. And therefore, my lords, that does not have any impact. The fact that, my lords, I have pleaded sale in Bangalore, which is not denied in the written statement, para 53 is sufficient, my lords, to create or constitute the jurisdiction. My friend's submission that registration was sought in Delhi, etc., is immaterial.
No, that is for the second leg of argument. If section 20 is not applicable as trial court said, your argument is that cause of action has been pleaded, then it cannot be rejected threshold from the trial. That is second leg of argument.
Ultimately, my lords, in a number of these cases, though my friend argued otherwise, in Intas as also in Davidoff, which is the judgment of our court, in both cases, the plaintiff was not residing within the jurisdiction of this honorable court. It was only on the basis of cause of action and additional remedy. Page 77, your lordships get that.
Yes.
Para 9, my lords, at page 77 of Intas, the fourth line, there is no denial of the fact that as of date of the trademark of the respondent is registered in India. In para 36 of the plaint, it was stated by the respondent as plaintiff that this court will have territorial jurisdiction to try and entertain the present suit as the offending product is sold by the defendant in and around Delhi within the jurisdiction of this court. Not that the plaintiff resides there. And so also Davidoff at page 94. This is a party who was registered in South Africa, my lords.
Yes.
The contention at para 6, the defendants who had entered caveat filed their detailed statement of objections to ISO and so and sought for dismissal of the applications. It was contended inter alia that the Bangalore court did not have territorial jurisdiction since the plaintiff nor the plaintiff's representatives are residents of Bangalore, nor plaintiff has its office at Bangalore. As such, the suit was barred under section 134 of the Trademarks Act. This was a South African entity, Zeno Davidoff SA. It's a South African entity. Even then, my lord, since the sale was taking place here, the Honorable Court found that the jurisdiction is vested. That is a plain reading of 134. If my learned friend's contention is accepted, not then the entire line of judgments, including the Supreme Court judgment in 2015, Supreme Court has no force of a precedent. Para 14 of the Supreme Court judgment clearly answers it. It's an additional remedy. I must tell your lordships, Lord, that the injunction granted by this Honorable Court has also been disobeyed by them. There is a contempt petition that has been filed and notice has been ordered therein.
That is different.
I'm just bringing it to your lordship's notice.
That is
No,
not,
my lord, that's what
I
when he stated, my two clients, his age may be seen, my lord. It's a family business. There's a will. I'm not arguing.
no,
with
that
it.
plaintiff and defendants are family members.
Yes, my lord, my both are brothers. My father filed the suit.
Yes.
My another brother, son, hijacked my father, got it 2022 when they released it. There is no partition in the family. Under the Samjhauta Nama, we are running the business. And this Vinod Chopra is the person who is instrumental, establish whole business.
No, why both are using the same name? Why can't that?
There's a Samjhauta
They
Nama
started in
Natraj
22.
in the family.
I'm using, my lords, my predecessor is using from 56. They copied it in 22.
Well,
If your lordship see the
he
mark,
is 32 years, I am 62 years. I am doing it from 1972 after death of my grandfather.
Anyhow, that why should I?
Yes, my lord. Yes, my lord.
my lords, Natraja, the dancing Natraja, the name is Natraja and the logo is also Natraja because it's God Natraja. Adhan copy madila.
ನಟರಾಜ ನಮ್ಮ ಫ್ಯಾಮಿಲಿ ಬ್ರ್ಯಾಂಡ್ ಅದು ನಟರಾಜ ಯಾರು ಹೊಸತ್ತಲ್ಲ ನಟರಾಜ
registration
ಎಲ್ಲ ನಟರಾಜ ಅಲ್ಲ ಡಿವೈಸ್ ಇಸ್ ರಿಜಿಸ್ಟರ್ಡ್ ಇಲ್ಲಿ ಎಲ್ಲಿ ಬಂದಿದ್ದು ನಾನು ನಟರಾಜಶ್ರೀ ಅಂತ ಇದು ಮಾಡಿದ ಕೂಡಲೇ ರಿಜಿಸ್ಟ್ರೇಷನ್ ಮಾಡಿಕೊಳ್ಳೋ ಕಾಸ್ ಬರ್ತದೆ ಇಲ್ಲಿ ಬಂದು ಟ್ರಬಲ್ ಕೊಡೋಣ ಅಂತ ಇಲ್ಲಿ
No, but they have registered before you.
Please.
I registered by 1956 then it is a
No,
Raja
then why
trader.
again you want to register if you are already registered?
Natraj ji, not Natraj. That what I mean is pending. That will be dealt by the authority. Whether it is similar or not, dealt by the authority.
That is not the concern.
Yes, their cause of action is that I have applied for the registration.
That you have pointed out.
Yes, my lord. For that was their filing case. Not their case that I am using Natraj. I am telling Natraj, see, that's what I am telling. To pass an interim order for using their registered brand, I am having no objection. Natraj Sri, Natraj Ji, everything they want. Natraj is nobody's property. Natraj is not registered by them. Natraj with a device is registered. Name is not registered. A device is registered. That I will
My friend is arguing the main plaint before
Yes,
you.
yes, madam.
Now that suddenly if I see time was showing 10 o'clock. Now it's changed that. I start going.
Sometimes your lordship sit even after court hours.
The brief was, I know this person from 1989. I used to purchase from them. They are in Sirsi. They are doing everything. Raj brand means
No,
famous.
this is using for sweets.
Sweets. That silver foil on sweets and on pan, my lords.
No, is
Especially
it
in the North
eatable or just only
No,
for
it's eatable.
eatable?
Yes, but it is in North Kendra madam. ಹವ್ಯಕರ ಮದುವೆಯಲ್ಲಿ ಕೇಸರಿ ಪಾತ್ ಅಂತ ಮಾಡ್ತಾರೆ. ಆ ಕೇಸರಿ ಪಾತಿ ಕೇಸರಿ ಫೇಮಸ್.
No, it will be made in which product?
Silver.
ಅಲ್ಲ
Edible
ಅಲ್ಲ,
silver.
ಕೇಸರಿ ಅದು ಅಲ್ಲ. It is a
ಅಲ್ಲ,
saffron.
ಈ ಸ್ವೀಟ್ಸ್ ಫಾಯಿಲ್ಸ್ ಹಾಕಿರ್ತಾರಲ್ಲ ವೈಟ್
Original silver, original gold.
original, but because we are consuming no, I'm
I don't know how healthy it is.
Then the ಕೇಸರಿ ಹೂವಿಂದ ಮಾಡ್ತಾರೆ.
we have seen that. It's in Kashmir, it's available. But this is foil. No, see, if you once you say that it is silver, it's all metal.
Yes.
Then we are consuming no.
We have to think twice.
So very less, there's a medically advised quantity. What they are putting, that medically advisable.
Yeah. Otherwise,
Yes.
they cannot do.
Yes.
Otherwise, it cannot be. Yes.
Grateful.
Reserved.
Interim order.
Interim order granted earlier will continue till next year.
Yes. We deeply obliged for the patient
Try
hearing.
to dispose as early as possible.
Yes, so great.
Serial number 51, I am appealing for the respondent, my lord.
Yes, madam.
In this case, we are filing but they are in filing the LR application, they are not served the copy, my lord.
No, that has been allowed in 2012, madam. Now you are asking.
Oh, sorry, my lord, I am very sorry.
Yes, none appear for the appellant. As a last chance, please this matter next week.
Number 56, Ramesh Babu for appellant.
Appellant. Next week, madam. Please this matter next week. Office is directed to what about the DS Krishna? Yes, now whose office is directed to delete the name of V. Ramesh Babu and DS Krishna of